Mr. Royal,
Yes, ma'am.
do you need a Creole interpreter?
Yes, ma'am.
Yeah. The thing is, I don't know that I can resolve your case today. But I can try to get, because you're gonna be in my division, I can try to get you in with me next week. Can we try to do that? And then I'll make sure I have a Creole interpreter as well. Is that okay, or do you want the interpreter? Are you understanding anything I'm saying?
Yeah, I want the interpreter.
You what?
Say it again one more time.
Let me. You can hear that all the way over there?
And lip reading as well, yes. Yes.
And that was why when we had masks, it drove me crazy. Because I tell people, I go, I'm so used to looking at your lips as well. I didn't realize how much I depended on it.
I say that to Miss George all the time. I can't hear you, which is a strange thing to say when, but yes, I can't hear you.
I may be able to hang up, but let me see. Hold on one second. I don't think she speaks Creole, and she seems to be doing pretty well.
He understands, Your Honor. He said he's okay having it set next week with the Creole interpreter.
Okay. And Mr. Royal, what I may do is I'm going to reach out directly, since it is in my division, to the public defender that's going to represent you, and then she can get with the other attorneys on your other cases. And as long as she puts in the motion, we may be able to get you out so that I don't even need to see you next week. But I just wanted to make sure all of everything is done before we let you go. Okay?
And in the meantime, I'll just enter a plea of not.
Yeah, we'll go ahead and put a plea of not guilty. This is going to be in Division 83, and the pretrial conference is going to be so February 20th, 8:30 and 6:00, but we'll see you before then. Or I'll get you out before then.
This is just for
What is that, man?
February 20th at 8:30.
February 20th.
20.
I'm gonna come in court.
We'll see you.
You say I'm gonna come in February 20th.
Come to court.
That says it right here. When you think I'm available to go?
Just 7.
Yeah, but nothing more, not for some.
Oh, no. You don't have anything. No, you're fine.
So you said, good. February 20th.
20 is the next court date. Not here, downtown.
Okay, thank you. Okay, Ray Lamar? Hi, good morning, or good afternoon, Mr. Lamar. Is your date of birth March 28th of 1964? Okay.
Your Honor,
Yes, ma'am.
with regard to 23 MM 671, possession of drug paraphernalia, state announces no information.
Okay. So, Mr. Lamar, the state went ahead and dropped the charges that you currently got picked up on. And then it looks like you just have court later on this open container, and we're not going to address that. So just make sure you stay in contact with your court date, so you come back for your court date downtown, okay? Thank you. This would be Henry McWhite. Hi, good afternoon, Mr. McWhite. Is your date of birth June 26th of 1954?
No,
Okay. So, Mr. McWhite, I have you here on 2023 MM 663AO. It's a charge of trespass. Do we want to try to resolve it?
Yes, Your Honor. The offer from the state is an adjudication of guilt, credit time served, and no return to 455 North Garland Avenue. Mr. McWhite would like to accept an interplea of no contest.
Okay. Yeah, on that last one, yes. Okay, Mr. McWhite, I do have the plea form that you signed. Did you have any questions about any of the information that's on the plea form?
no, ma'am.
And she says that you would like to enter a plea of no contest. Is that okay?
Yes, ma'am.
Did anybody force you or threaten you to do that today?
No, ma'am.
And you understand if you're not a U.S. citizen, entering a plea today could subject you to deportation.
Yes, ma'am.
Okay, so I will go ahead and accept your plea. I'm going to adjudicate you guilty. I'll give you credit for the 2 days that you've served here in the Orange County Jail, and I'll release you from this charge and this charge only. I am going to order that you not return back to the 455 North Garland Avenue. Now, that's the Lynx bus station, unless you have a bus ticket. If you have a ticket, I don't know that I can force him not to go there, right?
Right.
As long as it's a valid ticket.
So, and then there's court costs, sir, but I'll give you a year to pay the court costs back. If you don't pay it off in a year, they'll try to suspend your driver's license. If that's an issue for you, you can just write to me and we'll give you some more time. Do you have any questions?
No, ma'am.
Okay, you're all set. Thank you, sir. Good luck.
Thank you.
Hi, good afternoon. Are you Lawrence Maynard?
Yes, ma'am.
Okay, Mr. Maynard, were you born on January 1st of 1962?
Yes, ma'am.
Sir, I did review the charges in case number 2023 CF 1281AO. This is in Division 16. I'll go ahead and appoint the Public Defender's Office to represent you. I am going to set your bond at $3,500 on count 1. I'll reduce the bond to count 2 to $150. Count 3 will be $100. And I am going to order that you not return to that location on 27th Street.
Yes, ma'am.
Okay, good luck to you, sir. Thank you. Okay, good afternoon, sir. Are you Kevin Maurice Williams? And sir, were you born on January 21st of 1961? Correct. Okay. Sir, you are here on 2023 CF 1282AO. I have reviewed the charging affidavit in this case. I am finding that there's probable cause. Did you want me to appoint the Public Defender's Office to represent you? Oh, you did? Okay. Okay, so I'll go ahead and do that, and then I am going to stay the bond at $1,000 on count 1, and I will go ahead and reduce the bond on count 2 to $150. Okay, good luck to you, sir. Thank you. I have one possession of meth and possession of cocaine on Kevin Williams. Oh, yep, nope. It's okay. I don't know that he wanted the PD. I'll just go ahead and stay. So on that last gentleman, I think we messed up and thought that we had his affidavit of insolvency, but he shook his head that he did not want a public defender, so I'm not gonna give him one. Yes, ma'am. Okay, and is this Maria Hyatt?
Yes.
Okay, just make sure I went to the right list. You caught up? You want me to slow down? Okay. Ms. Hyatt, you are here on 2023 MM530AO. I do have the Office of the Public Defender that represents you on a charge of petty theft with a prior theft conviction, and she has 67 days.
Yes, Your Honor. Based on what I saw in the file, the attorney has competency issues and it's trying to have her evaluated.
Okay.
So I'd enter a plea of not guilty.
Okay, so Ms. Hyatt, your attorney's gonna enter a plea of not guilty on your behalf. That being said, we'll set this for a pretrial conference in Division 82.
February the 16th at 8:30, courtroom 9.
Okay, you're all set. Good luck to you, ma'am. Thank you. Jason William Scott?
Ma'am.
Okay. Mr. Scott, you're here on 2023 MM26AA. It's a charge of providing false identification to law enforcement officers. I don't have that he has the public defender's office, but he does have 58 days.
The offer from the state to resolve the case was an adjudication of guilt, credit time served. No, I didn't see any competency, Your Honor.
Is he being held on anything else?
I think this was transferred from a felony. I think
Yes,
it's
yes,
just-
ma'am.
I think he's just in on that.
Okay.
All right, thank you, no problem.
So, Mr. Scott, if I'm correct, entering a plea today would resolve this case and you would get out today?
Ma'am.
That's what you'd like to do?
Absolutely.
Okay.
Thank you, ma'am.
You're welcome, sir. So I do have the plea form that you signed. Any questions about the rights on the form?
Ma'am.
And you're going to enter a plea of no contest. Has anybody forced you or threatened you to do that today?
Ma'am.
And you understand if you're not a U.S. citizen, entering a plea could subject you to deportation?
Yes, ma'am.
Okay. So I'll go ahead and accept your plea. I will adjudicate you guilty. I'll sentence you to 58 days in the Orange County Jail with credit for the 58 days that you've previously served. I'll release you from this charge and this charge only. There are court costs, which includes cost of prosecution of $273. But I'll go ahead and give you a year to pay that back. If you don't pay it off in a year, they will try to suspend your driver's license. If that's an issue, just write to me before that year runs out and we'll give you extra time.
Ma'am.
Okay, any questions?
Ma'am.
You're all set. Thank you. Kiera Frazier? Hi. Hi, good afternoon, Ms. Frazier. You're here on 2022 MM320AE. It's a charge of petty theft. She has 34 days.
Yes, Your Honor. We're gonna do a global plea, so I'm gonna enter a plea of not guilty.
Okay. So I'll go ahead and enter a written plea of not guilty on this case. This is in Division 62, and it will have a pretrial conference.
March the 2nd at 1:30, courtroom 12C.
Okay. Teodros Kabedi?
Yes, ma'am.
Did I say your name properly?
Your Honor.
Okay, and sir, you're here on 2022 MO 1417AO. This is a city case for trespass with 37 days.
Yes, Your Honor.
I've been here since Christmas.
Okay.
And the offer from the state to resolve is an adjudication of guilt, credit time served, and Mr. Kabidi would like to accept and enter a plea of no contest.
Okay. Mr. Cavidi, I do have the plea form that you signed with your attorney. Do you have any questions about any of the rights that are on the plea form?
Yes, ma'am. I do have damaged lungs from being a lakeside patient.
Uh-huh.
I do have a car accident in Pine Hills where I reside.
Okay.
I just don't want to aggravate y'all with my retardation, to be honest, But I don't want to confirm that I'm going home today with what she said.
I believe so. Is this the only thing that's holding him?
Yeah, I don't see anything else
There's
holding
nothing
here.
else.
So, in layman's terms, I'm going home today.
Yes.
Okay, and I think she discussed that with me earlier. And I'm a citizen since '02, even though I have a foreign name. I'm a citizen since '02. Excuse me, I want to go home.
Okay. So she says you're gonna enter a plea of no contest. Did anybody force you or threaten you to do that today?
No, ma'am, she respectfully explained it to me. She just didn't know how to say my last name.
Okay. And since you've told me you're a US citizen, that
I became a citizen in
immigration
02 in
issues
in
won't
Shelby
apply.
County. I was in Shelby County in 02,
Okay.
West Tennessee,
Nope, you're good. So
White Station High School.
okay, I will go ahead and adjudicate you guilty. I'll sentence you to 37 days in the Orange County Jail with credit for the 37 days that you previously served. I'll release you from this charge and this charge only. There are court costs with the cost of prosecution and public defender lien. I'll give you a year to pay it back.
Yes, ma'am.
If you need longer than a year, just write to me before that year runs out and we can always give you extra time.
Ma'am, I just want to say something before I leave. I became a citizen in Shelby County at White Station High School in 01.
Okay, wonderful.
Thank you.
Thank you. Good luck.
And I'm going home today.
Yes.
Yes, thank you. Thank you.
No, you don't need this one. They're
Thank
gonna need it. Yeah, they're fine.
Yes. Alonzo Umberto Perry.
Yes, ma'am. How you doing? Good morning.
I'm good, sir. You're here on 2022 MM 8414AO. It is for a trespass. I show you has 47 days. I do not believe the PD represents.
Don't, Your Honor. This is the only thing holding him. The offer from the state was an adjudication of guilt, credit time served, no return to the 7-Eleven located at 83 East Colonial Drive. There's also a cost of investigation in the amount of $29.72 to the Orlando Police Department. Mr. Perry would like to enter a plea of no contest.
Okay. So, Mr. Perry, I'm going to get that plea form.
So that's-
Okay, so Mr. Perry, you signed the plea form. Any questions about any of the rights on the form?
No, ma'am.
And she says you're entering a plea of no contest. Did anybody force you or threaten you to do that today?
No, ma'am, they didn't.
Okay, and you understand if you're not a US citizen, entering a plea could subject you to deportation.
Yes, ma'am.
Okay. Sir, I will go ahead and accept your plea. I'll adjudicate you guilty. I'll sentence you to 47 days in the Orange County Jail with credit for the 47 days that you previously served. I will release you from this charge and this charge only. You are not to return back to 83 East Colonial Drive, which I believe is the 7-Eleven at that location. There are court costs, as well as a cost of investigation of $29.72. That's to the Orlando Police Department. I'll give you a year to pay that money back. If you don't pay it off in a year, they do try to suspend your driving privilege. So if that's a concern for you, just write to me before that year runs out. We can always give you extra time.
Yes, ma'am.
Any questions?
No, that's it, ma'am. Thank
Okay, good luck to you, sir. Thank you.
you. To you, too.
Rashawn Sims. Hi, are you Mr. Sims?
Yes.
Okay, so sir, you're here on 2022 MM 545AA. This is a charge of trespass. I show you as 34 days time served and that the public defender's office does represent him. Yeah.
Good with his sheet.
I can relay the offer while the council looks. It's an adjudication of guilt, credit time served, no return to the Dollar General located at 57 East Michael Gladden Boulevard. There's a cost of investigation of $117.25 to the Apopka PD.
Just trying to make sure, because on the sheet that I had, I write down here some issues of competency. I don't know.
Sure.
And I believe.
12/27/1987. Okay.
But he just had an evaluation January 23rd by Dr. Duros, and he found him incompetent, Your Honor. So I'm going to enter a plea of not guilty.
Okay. So, Mr. Sims, your attorney's going to enter a written plea of not guilty on your behalf. This is in front of Judge Wish in Division 82. There's going to be a pretrial conference. It's okay.
February 16th at 8:30, courtroom 9.
Okay. But I'm sure Ms. Waddell or one of the other attorneys in there will talk to you before then. Okay, good luck. Thank you. Rebecca Lynn Foster? Is that you?
Yes, ma'am.
Okay. Ms. Foster, you are here on case number 2023 CT89AE. It is a charge of driving while license suspended or revoked. She's got 9 days, and the public defender's office represents her.
We're gonna enter a plea of not guilty, Your Honor.
Okay. So ma'am, I'm entering a plea of not guilty on your behalf. This is going to be set in Division 85 with Judge Allen. Her pretrial conference is
March the sixth at 9 a.m.
okay. Okay, good afternoon, ma'am. Are you Crystal Lee Hollowell?
Yes, ma'am.
Okay. You're here on 2023 CT85AE. It is a charge of driving while license suspended or revoked. She has 11 days with the public defender.
We're gonna enter a plea of not guilty, Your Honor.
Okay, so ma'am, we're entering a plea of not guilty on your behalf. This will be in Division 84 with Judge Steve Jewett. It'll be a pretrial conference.
For March the second at 8:45, courtroom 4B.
Okay. Jose Mayhew? Hi, Mr. Mayhew. You're here on 2023 CT59AA. It's driving while license suspended or revoked. I've got 29 days total. I do not have the public defender appointed as his attorney, though. I can
Your Honor, I
appoint
just
them.
asked that you appoint, I don't have I tried to pull his record, I don't have his driving record, so I don't know how many, driving while license suspended this is, but he's also being held on no bond on some other charges, if I'm not mistaken. Is it this one? Oh, this is the only one, he's on no bond. So I don't have the driver record, could you let me know if this would HTO?
Let me-
This is your third.
So if I'm looking at this correctly, the state filed it as driving while license revoked as a habitual offender, failure to pay. It's an M2, but it sounds like his license got habitualized in November of 2022. So can I tell him something? So Mr. Mayhew, what we really need to do is, when you were trying to get your license back, you were doing everything that you were supposed to because you went and paid all the tickets. But you paid for some tickets that were driving while license suspended without knowledge. They're not criminal, they're civil, so they're kind of like a speeding ticket. The problem is nobody tells you that if you just go to the clerk's office and pay them, that they can habitualize your license. So that's what happened. You got one of those, two of those. So you got one in Orange County, one in Martin County, and one in Lake County. So if we can, we flip them, and we flip them from adjudications to withholds. It takes about 10 days, depending on if the clerks send it straight to Tallahassee. But then that gets rid of the whole HTO on your license, so you get your license back, and then we give you some time to try to get your license. Is this the only thing? Oh, he got pulled in on the felony, and then they reduced it. Did he get out on?
They did, Your Honor, but the reason he can't bond is because of this charge. They're holding
They
him.
no bonded him.
Mhm.
Okay. And that was, hold on one second. We got the, what happened to the, 2023 CF41AO? He's bonded out on that?
No,
No,
he
he
has a
didn't-
bond on it, though.
He didn't post the bond because he's being held on no bond on this charge.
There's no point in it. Gotcha.
Right, so he can post the bonds, but he still couldn't get out because of this.
What was that charge, if you don't mind me asking? That 41?
Same.
He's in on a duelis. Again, a driving while license, revoked, suspended.
Do you have an objection if I set a bond? Judge Carabai is the one that revoked his bond, and she did it because he was out on a duelist, but he's now got 29 days. If I could get him out to get with his public defender, I could flip the HTO. I can text her if it would make you feel better.
It would, Your Honor.
Okay.
It would. I apologize for having to jump through the hoops. But
No,
yes, it
not at all.
would. Thank you.
Actually, you know what? Hey, Tina, it's Martha Adams. Hey, can I ask you a quick question? You were doing IAs, and a gentleman named Jose Mayhew picked up a driving while license suspended while he was out on bond for driving while license suspended. They no bonded him. You no bonded him. He's got 29 days in, but if I can get him out and get with his PD, if we can flip one of his civil infractions, we can get the HTO off his license. Nobody told him that when he was paying his tickets. He's trying to get his license back. Do you have any objection if I give him a bond? Okay, thank you. I know, but the state wanted to make sure it was okay with you. I got no valids. See, it looks like somebody was trying to help him out because I got no valid, no valid. Then he does get one criminal in October of 2018. And a no valid. But then he's got 3 civil infractions, one in Lake, one in Martin, and one in Orange. But you're right, even if I flip the one in Orange, it's not gonna take it away. He's gotta flip the one in Martin or Lake, but the PDs have been able to do that. They have them file their own little motions. Right, okay, thank you so much, I appreciate it. Okay, bye. She got a good memory. So she said she does not have a problem with that, but you do need to talk to your PD because not only are we gonna need to flip the one in Orange, but we're gonna need to flip one of them in Martin or Lake. It's my understanding the PDs can't do it because they can't represent you in these civil infractions if they're not in Orange County, but they give you the same things that they send to the judges. It just has you do it on your own, okay? So Mr. Mayhew, I'll go ahead and set your bond at $500, but can you do me a favor and please don't drive without a driver's license? Because if you keep getting pulled over and keep getting these criminal charges, it kind of, it makes sort of, it gives no purpose to what we've just done, okay? He does not have it, no, he did have a PD on the felony, so wouldn't the PD roll to the misdemeanor? Okay. So let's do this. I'll go ahead, he does have the PD on this charge because they were representing him on the felony. This will now be in Division 84 with Judge Steve Jewett. We'll set it for a pretrial conference.
March the 2nd at 8:45
Okay. And I'll set his bond at $500 with do not drive without a valid driver's license, and contact your public defender as soon as possible, okay? You're welcome, sir. Good luck. Okay. We'll enter a written plea of not guilty. He doesn't have the PD. I'm gonna go ahead and appoint the public defender to represent him.
Yes, Your Honor.
We'll enter a written plea of not guilty. It'll be in Division 80 for a pretrial conference.
February the 24th at 9 a.m., courtroom 9C.
How about Shaquille Irby?
Yes, ma'am.
Hi, Mr. Irby. You're here on 2023 MM 100 AO. You do have the Public Defender's Office appointed. It looks like they've got a 2-count information. He's got 27 days in.
There's no offer, Your Honor. We're gonna enter a plea of not guilty.
Okay, this will be a written plea of not guilty. It's in Division 62. That has a pretrial conference.
On March the 2nd at 1:30 p.m., courtroom 12C.
Oh, he's got 2 cases. He also had 2023 MM 109 AO. That's also in Division 62. So we'll do a written plea of not guilty on that case, and it'll have the same pretrial date of March 2nd at 1:30 p.m. in courtroom 12C. Next case I have is DeQuayne Laster.
Private. He has private
I
counsel?
went to,
Oh, you have Mr. Carestis?
yes, ma'am, I just went to court this morning for it.
Oh, you did? Okay.
ma'am.
And that's quite possible. Sometimes they just don't tell us those things. Okay.
So is
Well,
the bond still set at what he said this morning? Yeah, he got me a bond, I had a bond hearing this morning.
you had a bond
Yeah,
hearing?
it looks like his bond is pending too, so it looks like,
Okay. So what I'll do is I'll just go ahead and note that he's probably already entered a plea of not guilty. He hasn't?
No, ma'am. He just told me that the bond was $1,000 and then
Are you gonna, have you hired him to keep representing you, or do you want the public defender?
So the problem, the issue that with this case right here is that I guess it was a conflict of interest with me and my wife at the time, so they wanted me a bar lawyer. So that's why I was appointing him due to a conflict of interest. So they deferred me from the public defender's office. They sent me a letter deferring me to Mr. Caresi. So my question, ma'am, are you able to update it showing that I have a bond? So that way my bond can process it?
Yeah, she shows the bond as pending.
yeah, they're working on it.
I just need to figure out,
Like my bond already paid for?
So,
Yeah, I was like, as soon as I got back from downtown, they just had a missed me this morning.
I also don't know. So it's regional conflict counsel. The only thing that may be different is because sometimes the attorneys change based on whether you're in a circuit division or a county division. So you may not end up with Mr. Carestis for the felony, but you still have the Office of Regional Conflict Counsel.
So I have two excuse me, so the charges that I have, the methamphetamine felony I know my PD on that as well.
Yes, so because they took this case was originally as a felony and brought it down to county court, I'm just saying Mr. Cresties might not represent you on this anymore, but let's go ahead and set him for the pretrial with Judge McGinnis.
Case to be heard in Division 53, trial is March the 6th.
So that,
So when you had your bond hearing this morning, did Mr. Cresties come and represent you?
yes, ma'am.
Okay, then he may keep it then. What I would do is just go ahead and bond out with the bond that you guys talked about this morning, and then we'll give you that pretrial date, March 6th. He's regional conflict counsel, so it's kind of like the PD. So we'll leave it at 9 a.m. and then just talk to Mr. Cresties. He'll make sure that,
So is my bond pending process, like, to be processed out already, or do I still have to post it?
He's bond pending, so.
it sounds like somebody posted it for you and they're just probably waiting for you to finish up here and then they'll get you out.
Okay.
Okay, good luck, sir. Thank you. This is Mr. Padula Smith,
That was Belcher.
Belcher. Okay, did I miss arm or
It was behavior, Your Honor.
behavior? Okay. He does have the public defender. Can I enter a written plea of not guilty?
Yes, Your Honor, and I will waive.
Okay, and that's gonna be in Division 84 with a pretrial conference.
March the 2nd. At 8:45, courtroom 4.
Okay, and that brings me to you, Mr. Belcher. Mr. Belcher, were you born on May 28th of 1963?
Yes, ma'am.
Okay, so you are here on case number 2023 MM 668AO. This is a charge of trespass. Was there an offer in this case?
Yes, Your Honor.
Okay.
The offer from the state is an adjudication of guilt, credit time served, no return to Winn-Dixie located at 1401 South Hiawassee Road, and Mr. Belcher would like to accept and enter a plea of no contest.
So, Mr. Belcher, you did sign the plea form. Do you have any questions about any of the rights that are on that form?
No, ma'am, but the reason that I was there,
Don't talk about that, just resolve it.
So I just want to ask you, she's saying you're going to enter a plea of no contest. Did anybody force you or threaten you to do that today?
no, ma'am.
And you understand if you're not a U.S. citizen, entering into a plea could subject you to deportation?
Yes, yes, I am American citizen.
Okay, wonderful. So I'm going to adjudicate you guilty. I will go ahead and give you credit for the 2 days that you'd served previously in the Orange County Jail. I'll release you from this charge and this charge only. Just going to order that you not return back to that location at 1401 South Hiawassee Road. And then there are court costs, but I'll give you a year to pay that back. If you don't pay it off in a year, they'll suspend your driving privilege. If that's an issue for you, we can always give you more time if you write to me before that year runs out. Okay, good luck to you, sir. Thank you. Shantice Ewing,
Police PTR.
PTR, okay. Mario Jean-Jacques? Okay. Mr. Jacques, is your date of birth June 11th of 1967?
Yes.
Okay. So, sir, you're here on 2023 MM 664AO. It's a charge of trespass.
Your Honor, there was an offer, but he has no history, so I was gonna ask for an ROR. He may qualify for pretrial diversion to try to keep it off of his record.
Sorry, I had it, but I moved it. He does not qualify for PTR. Is that based on the deportation?
That probably contributed to it, plus, I guess looks like we didn't get all of our questions answered and we weren't able to verify any information he gave us.
So I do have that he was deported back in 2009. That being said, though, they just weren't able to verify any of the community ties or anything like that.
Okay.
Has anybody put a hold on him?
Speak to you about it. Yeah. So Your Honor, even when I went back to speak with him, there was kind of a disconnect, trying to relay the information because his primary language isn't English. And so I'm pretty sure the same thing happened when pretrial tried to come talk to him, because it was saying, some of the questions he didn't answer. One of the inmates actually tried to help assist me in speaking with him. So I think that's what it is. I think it's the, language barrier.
Okay.
that-
Mr. Jacques, do you speak Creole?
Yes, I do.
Okay. So let me just ask, did you see if there's any holds for him?
There's no holds.
There's no hold.
No.
Okay, well, that's a good sign. I can reset him to tomorrow. I can give him a bond, I mean, he's got a bond. I can reset him to tomorrow, get a Creole interpreter, and then try to see if, let me just ask, even if you verify certain ties, the likelihood he gets out?
I mean, he didn't provide us with a lot, so,
He needs to provide you with a lot?
with a little bit more than what he did.
Yeah, absolutely.
So I don't know.
Gotcha.
I couldn't say.
No.
Oh, yes.
Okay, Your Honor, you can set a bond if you're not willing to RO.
Just keep him set bond at 500? Okay. So, Mr. Jacques, we'll keep your bond set at $500. Did you want me to appoint the public defender's office to represent you?
Yes.
Okay, we'll go ahead and do that, and you're all set. And just no return back to that location, okay?
Okay.
Thank you.
Okay.
Jamie Matthews? Hi, Mr. Matthews. Were you born on July 15th of 1976? Okay. So I have you here on 2023 MM63AW. It's a charge of Schedule 5 drug, what is this?
It said manufacturing, but I think it was just possession, Your Honor.
It's for meth. I don't understand how that's a, yeah.
Okay, well, that's very unusual. I'm assuming there's not an offer on this, right?
No,
No, Your Honor.
Yeah. So, am I addressing this FTA out of Lake County or no?
It's just a hold. He's not in on it. He just has a hold for Lake.
Okay.
Oh, no, Your Honor.
Okay. So, I'm not sure how it got filed that way, but okay, I will go ahead. I do find there's probable cause. I'll keep the bond set at, $1,000 on count one. I will drop the, count two to $100. I'll appoint the public defender's office to represent you. Okay, good luck to you, sir. Thank you. Nolan Otley Francis. Bonded. Michael Vernon Rouse.
Mental health.
What would you like me to do on Mr.?
Didn't, actually,
There's no offer.
no, I know. Not on this case. On the out on bond you guys filed on the camping, so I was gonna ask to resolve it. It was just filed.
Oh, I didn't check.
So can we,
Will you
set
roll-
for tomorrow to resolve the out on bond?
Sure. We'll reset that one to tomorrow. This brings me to Jason Matthew Neal. And let me get to this. Okay.
Do you have the case number, Your Honor?
Yeah, Mr. Neal is here on case number 2023 MO 160AO. It's an alcoholic beverage open container.
And the offer from the state is a withhold of adjudication, credit time served, And Mr. Neal would like to accept and enter plea of no contest.
Okay. Mr. Neal, I'm gonna get your plea form that you signed. Did you have any questions about any of the rights that are on that form? And she said you'd like to enter a plea of no contest. Has anybody forced you or threatened you to do that today? And you understand if you're not a US citizen, entering into a plea today could subject you to deportation. So I will go ahead and accept your plea. I will withhold adjudication. I'll give you credit for the 2 days that you've served in the Orange County Jail with credit for those 2 days and release you from this charge and this charge only. There are court costs, but I'll go ahead and give you a year to pay that back. If you don't pay it off in a year, they do try to suspend your driving privilege, so write to me before that year runs out if you need extra time. Because you are resolving the underlying case, or this case, this new case, I will not take any action on the case that you're currently out on bond. But Mr. Neal, just keep in mind, if you keep getting arrested while you're out on bond, you run the risk of being held with no bond at all, okay? So good luck to you, sir. Thank you. Raymond Seals. Okay. Next, I have Christopher Bouvard. Okay. How about Montia Alston D'Angelo? Is that you? Okay, give me 1 second just to catch up this part. Oh, it's D'Angelo Alston. I apologize. So, Mr. Alston, I just want to verify your date of birth is August 5th of 1987. Okay. So, sir, I have 2 cases here. I have, let's do this one first. 2023 CF 1060AO. That's in Division 17. I will go ahead and appoint the Public Defender's Office to represent you. Judge Starr is the one who signed off on the warrant finding probable cause. She set your bond in the amount of petty theft, or in the amount of $2,500 for the charge of petty theft with 2 prior theft convictions.
I don't have 2 priors.
Okay, well, that's something you can talk to your attorney about, and that's in Division 17. And then it looks like I have the second case is 2023 CF 1293AO. I'll appoint the Public Defender's Office to represent you. This is for a charge of possession of methamphetamine. I'll go ahead and set your bond in the amount of $1,000. That's in Division 22 with Judge Harris. But I am noting that you're currently out on bond for possession of methamphetamines and possession of drug paraphernalia. It looks like you just got released on the 9th of this month.
Yes, Your Honor. The state has not made a final decision, so I have to take no action. He was arrested December 6th.
The state wish to be heard?
Your Honor, it's common knowledge that these FDLE reports take longer than 30 days. As is right now, Mr. Alston has been arrested. You said, so he's been arrested within 3 weeks of being released on a new offense, Your Honor.
I'm more concerned about that it's the exact same charge. So I am going to go ahead and revoke the ROR in case number 2022 CF 14111AO. We'll go ahead and alert the Public Defender's Office in that division, Division 17, to know that we did revoke the ROR and the bond's been set at none. Okay, good luck. Thank you. LaShawn Bourne.
Bonded.
Calvin Brooks. You're Mr. Brooks?
Yes.
Okay. Mr. Brooks, were you born on September 8th of 1984?
Yes.
Okay. So I think there are 4 cases here. Let's just go down the order that I have them is 2022 CF 1455280. It's an arrest warrant signed by Judge Nick Walker. She has sale and delivery of cocaine, count 1, $750 bond, count 2, possession of cocaine is $250 bond for a total of $1,000. That's in Division 12. I'll go ahead and appoint the Public Defender's Office to represent you. The second case I have is 2022 CF 14550, 14550, yeah. Sorry, that one's in Division 16. I'll appoint the public defenders. Again, Judge Nick Walker, set your bond, $750 on count 1, $250 on count 2 for a total of $1,000.
That's what it is. It's 750 and 2, right?
I was confused.
Then the third case is 2022 CF 14548AO.
There you go.
That's out of Division 20. Same thing, Judge Nick Walker has your bond at $750 on count 1, $250 on count 2 for a total of $1,000. I'm appointing the public defender. Then the last case I have is 2022 CF 14544AO out of Division 16. Again, bond set at $2,500 on count 1, $500 on count 2 for a total of $3,000, and I'll appoint the Public Defender's Office to represent you. Okay? Good luck to you, sir. Sure. How is that possible? Okay, well, you're gonna have to get, that's not, all I'm doing is telling you what Judge Michaela, Nick Walker found. Okay, well, that's why we got you a public defender, so that you can get back in front of your judge to tell them something differently. Yeah, I just stayed the bond.
In the same month, and I've never been arrested.
These are for incidents alleged to have occurred in August 16th of 2022, August 17th of 2022, September 16th of 2022, and September 16th of 2022. Okay, well, I'll let you talk to your attorney. Good luck to you, sir. Thank you. Marcus Brown? Okay, Mr. Brown, is your date of birth June 26th of 1983?
Yes, ma'am.
Okay. So, sir, you are here on case number 2023 CF 1295AO. I did review the charging affidavit. It is in Division 16. I'll go ahead and appoint the Public Defender's Office to represent you. I am going to stay your bond at the amount of $1,000. Okay? Good luck to you, sir. Thank you.
Your Honor, he is out on bond. That was found before court. It's in 2020 CF 007091 AO. It's 2020 CF 007091 AO.
Give me just 1 second. So, Mr. Brown, let me ask you a couple things. It looks like Mr. Ferry represents you on that case. Did you want me to see if Mr. Ferry will represent you on this new charge? Or do you want me to keep the public defender on the new charge?
I'll possibly go with Mr. Perry.
Okay. So, let me just look at one thing. regards to the case that he's currently out on bond for?
I'm reading the synopsis on that, Your Honor, but it has been filed and there is pretrial that's set for March 22nd, but I am just reading the facts right now, Your Honor, or the synopsis, I should say. Your Honor, based on the fact that the out on bond has been pending since 2020, and this is carrying a concealed firearm, though they're not related, I would still ask for the bond to be revoked and defendant be held no bond.
So, Mr. Brown, let's do this.
Miss, on this situation, I didn't know my.
Don't tell me anything about the facts of this case, because I don't want you to do that. Here's what I'm gonna do. And Mr. Brown,
All I'm saying is I was arrested with my concealed weapons license permit. I didn't.
okay, well, unfortunately, the deputy says that because there's currently an injunction pending, that the state of Florida revoked your concealed weapons permit. So, that's an issue. So let me do this. The concern that I have is the nature of the charges that you're currently out on bond for. They're not just, a simple possession or something like that. What I'm gonna do, sir, is I'll go ahead and leave the bond at $1,000 on the new law violation. I am gonna revoke your bond in case number 2020 CF 7091AO. But I will give Mr. Ferry a call right now and let him know that you're being held without bond, and he can try to get you back in front of Judge Navarro to see if she wants to take all of those things into consideration, as she'd be far more appropriate to do that.
Miss,
Uh-huh.
why, excuse me, why is the new bond being revoked and I didn't have any knowledge of what?
I gave you a bond on the new law violation. I'm revoking your bond for what you're out on bond for.
I'm talking about the old bond.
Yeah, because you're not supposed to be getting into trouble while you're out on bond. You're not supposed to commit new law violations or anything like that.
Yeah, yes, ma'am, I understand that, but like I was saying before,
Stop.
I understand, I understand.
I understand what you're saying.
I didn't have any knowledge.
Okay. No, because he says he wants Mr. Ferry.
Your Honor, are you willing to revoke and double the bonds as opposed to holding him at no bond as a friend of the court, being that he has a private in that case? It's not my case, so I don't know how to argue.
I'm having a hard time with this computer. That's 5,000, 5,000, 2,500, 2,500, 100, 100, and 7,500.
275.
They filed on 5 counts. Yeah. It's,
So what's the total amount he's currently out on bond?
it's, the counts that they filed on, I believe it's 5,000, 5,000, 7,500, 2,500, 2,500. So. I was gonna say, I'm not great. Well, it's 10,000, then it's a 7,500, so
15.
17,500, and then 5,000.
Huh?
Was that 22,500 total? If I'm doing math right?
So then if I doubled it, it's $90,000. I'll double it and I'll make it $90,000, but I'll also call Mr. Ferry and let him know that you're here, okay?
So what do you put on each count, Your Honor? Because we have to write it out on
Oh.
a count.
Sorry, I forgot. So, let me just look at that.
And it's five counts that they filed on.
Let me look at the information. I'm basically doubling on each count.
Okay. Okay.
I just can't, I can't.
Do you want me to tell you? Okay, so it would be, count one would be 10,000 then. Count two would then be 10,000 again. And then 7,500 times two is 15,000?
Yes.
Yes, so 15,000 on three. Then it would be 5,000 on four and 5,000 on five.
Okay,
I think.
perfect. No, you're right. Okay. Okay. And you are Kenneth Cabrera?
Yes,
Mr. Cabrera, were you born on October 10th of 1996?
November 10th.
November 10th? Okay. So, Mr. Cabrera, I have you here on two cases. Well, let's do this one first. So I have case number 2023 CF 12960. It's possession of cannabis and possession of drug paraphernalia. I will go ahead and appoint the public defender's office to represent you. I am finding probable cause. You do qualify for pretrial release, so I'll go ahead and release you on the conditions of pretrial release with the conditions that you not possess any illicit substances. Should we maybe not drug test you for 30 days, just to be safe?
Okay. He has his license, so it's fine, Your Honor.
Okay, so we'll go ahead and do that. And then on the 2022 CF 12089AO, that is a warrant that was signed by Judge Duckworth for fleeing and attempting to elude. You are entitled to a bond on that one.
I'm gonna ask for pretrial release as well, Your Honor.
State have any objection to that?
No objection, Your Honor.
Okay, so I'll do pretrial release on that case as well. And you're all set, okay?
Any conditions with that one, Your Honor, or just
No,
no drug out? Okay.
keep it on the other one, yeah. Yes, ma'am, on the drug charges.
Got it, okay.
It's your number.
Okay.
Hi, Willie Carr. Good evening, Mr. Carr. So you are here on case number 2023 CF 12890. I did review the charging affidavit in this case.
I'm sorry. On the given false ID, or given false information, the only PC challenge I had was that it didn't state what information was given. The officer stated he gave him a false name, but that's it.
I thought,
It wasn't this one.
Oh, it wasn't this one? I thought it was
It's
this
another
one.
one.
Sorry. I
Sorry.
was looking at the wrong one, Your Honor.
because I was like, there was two of them. I thought he,
On
One
this
of
one, I believe it's fine. There was another one a few.
That's, okay.
Yeah.
okay. So I am gonna go ahead and I'll keep the bond set at $3,500 on count one and $100 on count two. So informations have been filed on both of the other two cases that he's currently out on bond for, and they're not the exact same thing. Well, they are on count one, but on count two, there's petty theft. So I am gonna revoke his bond in case number 2020 CF 15004AO. That's in front of Judge Harris, Division 22. He has the public defender, we'll notify them, as well as in case number 2022 CF 12036AO. That's in Division 15 with Judge Weiss, and he has Devin Desai from the PD's office, so those bonds will be revoked. Okay?
Thank you, Your Honor. That's it. This is yours.
Luther Coleman?
I thought when I read it, it didn't.
Hey, Mr. LaFay, are you here on a defendant?
I am, Your Honor, and his name is Yugendra Tiakram.
Yes.
Good to see you, Your Honor.
Good to see you. Let's see. I know he's in here somewhere. Okay, so, and is this Mr. Tiakram, is this your client?
It is.
Okay, and Mr. Tiakram, you were born on January 28th of 1995?
Yes, ma'am.
Okay, so this is case number 2023 CF 1297AO. So, Mr. LaFay, obviously, you know, my concern is that the robbery with a firearm is punishable by life, so I don't know that he's necessarily entitled to a bond on that count.
He is not. It would be discretionary at this point, and I'm familiar with the Florida Supreme Court, I would say fairly recent holding about Arthur hearings, so I'm not asking for an Arthur hearing here today, but I do have some arguments about probable cause with regard to robbery with a firearm.
Okay.
And I also have some testimony from Mr. Tiakram.
Okay, well, tell me what you have. I read over it and it seemed okay to me, but what would you like to tell me?
So there's a couple of things about the gold chain. First, I think a fair reading of the arrest affidavit is that the chain was torn off during a fight. Second, the chain was not found in Mr. Tiakram's possession, not in the SUV that was searched and not on his person. So he didn't have the chain. Understanding it was torn off in mutual combat. The fight, I would note, per the arrest affidavit, it didn't end with the tearing of the chain. So with a robbery, for example, once the goods are in hand, typically you might expect the robbery to be over with, but there was mutual combat before the tearing of the chain and mutual combat after the tearing of the chain. I would note that witness Rajan never even mentioned the chain, but of course victim Ryan did. So that said, I would say that there's understanding that the chain may have been torn off and hit the floor or something, but it just does not seem to be, these facts don't seem to be in conformity with or consistent with a robbery. That is to say, with taking something intentionally with the intent to deprive.
But you have no issue with the probable cause for the aggravated battery with the firearm?
I do not. I think that's set forth in the affidavit.
Um, No, can I just ask you specifically, because if you, obviously, and I'm assuming this is where maybe your client's testimony would come into play. The alleged victim in this case claims that your client ripped the gold chain off of his neck. It doesn't sound like, the way I read it, it didn't sound like it just kind of came off while they were fighting. It sounded like it was ripped purposefully as part of the fighting, but you're saying differently?
Well, it says, I'm concentrating on the first prepositional phrase there. During the fight, suspect one ripped his gold chain off his neck. So I'd say it could be that somebody formulated the intent in mutual combat to take a chain. I can't say it's mutually incompatible or mutually exclusive. I'm just saying, without the chain being in the person's possession, moments later when the SUV is stopped, that would seem to be the linchpin fact and would seem to argue that the chain came off in mutual combat without the intent to commit a robbery.
Okay. Well, did the state wish to be heard?
Your Honor, I would disagree. I understand that you do have the discretion to set a bond. However, this was 4 individuals against 1. There was a fight, which if it had just been the 2 individuals, that would have been fine. But a second individual used a cricket bat. This defendant is alleged to have shot 2, fired a gun in the air, and then pistol whipped the victim while he was already on the ground. Whether the chain was found in his possession or not is irrelevant at this point, as they were all acting in concert. And therefore, it's still a robbery with a firearm.
Mr. LaFay, what else did you want to tell me?
I did not see anything about individuals acting in concert to commit a robbery. I would say numbers seem to be 4 against 2, but that said, it just seems to be a bar fight where a pistol was alleged to have been used in the bar fight. And it started as a bar fight. I don't see how somehow it morphed into a robbery when none of the fighters were in possession of the opposing combatants' possessions.
Well, let me ask, if I can, from pretrial services. It says he wasn't interviewed. I don't have anything, but then it also does indicate that.
Hey, Your Honor, I can give you an updated form.
Okay. There we go. Perfect.
It's my understanding that my client doesn't have a prior record, but
I don't know about that. I have that he pled to a reckless driving that was reduced down from a battery back in December of 2021. But then I also have that he has a history, arrest history of burglary with assault or a battery, aggravated assault with a firearm, tampering with a witness to hinder communication to law enforcement, and felony battery. Now, I don't show that he has necessarily convictions on those, but just arrests.
I believe, I think I was the attorney of record on the majority of those, and this is the best my memory is, Your Honor, and this is, which it's not doing better as time goes on. But that said, my understanding, which is why we don't see possession of firearm by convicted felon here is that I know there are no felonies. That I do know. Whether there's one count of battery or not, I just don't know. I don't think so, but I don't know.
It's a 2015 case.
2015, there was a battery.
Yes, sir, which was also a violation of probation.
So I think that confirms my memory that there's, I think, one count of battery and apparently a reckless driving, but I don't. And a reckless driving.
Felony charge got reduced down to a misdemeanor battery that he pled to. Then there was a violation of probation, but that got dismissed.
So I'm going to amend my remarks to a somewhat, I don't want to say negligible criminal record, but misdemeanant. And then also, Your Honor, I did, whenever the court's ready, I have some testimony from Mr. Tiaquin.
Felony battery was no insured, but then there was also it looked like you might owe some money on a C2 case. Anyway, that's the clerk's office, and I have an ongoing issue about that. Well, clearly your client's upset, and I understand that, because I think he realized this was not good. But if I'm looking at this, that he's currently employed full-time at a auto sales as executive management?
It is. I think that's his business, Your Honor.
And you're young, you're 28. Are you married?
Yes, ma'am. I have a kid 4 years old, and my wife is pregnant 4 months.
Okay. So you have one child that's 4?
4 years old. She was 20th of January, was
Her birthday?
me and her is the same day.
Okay.
She just came back from vacation.
Okay. And then your wife is currently pregnant. When is she due?
And she is 4 months pregnant.
Okay. Do you know her due date?
Okay, it's February or something. No, it's 5 months from now.
Okay.
She is 4 months.
Is that his family, maybe?
Yes.
That is,
His wife?
that is Mr. Tiakram's mother and wife and likely daughter.
Did you want to take testimony from them on anything?
No, Your Honor, I had testimony from Mr. Tiakram about his ties to the community. I think it's already well established. I would simply ask him otherwise. If he owns his business, if he owns or rents a house here, the testimony would be that they own their house, that he's lived in the community for a significant time, and that he's never failed to appear for court.
So this case is in front of Judge Brownlee in Division 17. And I don't want you to say anything, so don't answer. From the state, the way I'm understanding it is, did you get the impression that they stopped the vehicle so they were able to get this defendant, but any of the other suspects, those are still at large? I didn't see anything about arresting anybody else.
I did not see that either, Your Honor. I think it was just because he fled in the vehicle.
Right.
And they were able to trace it that way.
Factually, Your Honor, I would say that normally you'd look at a green jumpsuit and say, well, if that isn't a distinguishing feature, I don't know what is. But with a cricket team, with the cricket team at the bar, you would come to understand that, in fact, everybody had on a green jumpsuit. It's their uniform, to the extent that makes sense.
Oh, I see what you're saying. I'm sorry, I wasn't following you at first. Okay. Is the Sip and Chat a popular cricket bar? Yeah. It's not one I'm familiar with, but God bless you that you play cricket. I cannot figure that game out to save my life, so. So, Mr. LaFay, obviously, your client clearly stepped in it this time. That's a nice term of saying it. But what would you think would be an appropriate amount of bond?
I would ask for $15,000, Your Honor. The grand theft is double jeopardy with the robbery. Therefore, I would say that would be on a release on his own recognizance, and $7,500 apiece for the other two.
Here's what I'll do. I am finding probable cause, but see, that's my problem. I think if I find probable cause, my hands are tied. think that's the problem that I have, is that I do find probable cause, and if I find probable cause for the robbery with the firearm, then the bond has to be set at none.
Well, the court still has its discretion.
Does the state agree?
The state agrees that the court does have discretion. The state would object.
Here's what I'll do. I will go ahead, I'm gonna set bond, I'm gonna set it at $50,000. I don't like 15. The facts of this case, even if you take out the fact that the necklace is not a robbery, the entire facts surrounding it are just not very pleasant. So I'm gonna keep, count one, the bond will be set at $50,000. Count two, I'll do a $500 bond. And count three, I'll lower the bond to $500 as well.
Your Honor,
Are you gonna try to look a gift horse in the mouth?
the only thing, first, thank you. My final request would be, would the court consider 30,000 on count one? The reason I say that is that I believe that Mr. Tiakram's mother would be handling the finances, and I know she has just suffered a financial setback at the hands of, well, Nejam Law, PA.
I'm either going none or 50, so which one?
I'm going to take the 50. Thank you, though.
Let's go with
Your
that.
Honor, if you note, this defendant is from Guyana, so I would also ask that he surrender his passport.
You have a passport?
Yes.
That's fine.
Okay, thank you. And obviously, sir, no contact with the victims in this case, and victim slash and witness, and then let's not return back to the sip and chat for a while. Okay,
I wouldn't go back, man. Thank you.
you're welcome. Good luck.
Thank you, Your Honor.
Thank
Good to see you, Your Honor.
Good to see you too. Thank you. Okay, now we're at, now I'm not sure where we are. This one? Coleman?
Yes.
Okay. And Mr. Coleman, is your date of birth November 20th of 1966? Okay. So you're here on 2023 CF 1268AO. This is in Division 22. I have reviewed the charging affidavit. I am finding there's probable cause. We'll appoint the public defender's office. Your bonds will be stayed at $3,500 on count one, $100 on count two, $100 on count three, and $100 on count four. I am gonna order that you not return back to that location at 1316 D Rock Drive. Okay, good luck to you, sir. Thank you. John Charles Davis? Sure.
And I did have a PC challenge, Your Honor.
Is this the one?
Drugs, the meth. That was not tested.
He said, I knew it to be crystal meth. And then he weighed it. Yeah. I thought maybe I was missing something. Do they not test it anymore? I thought there's, I realized they're sending it straight to FDLE, but they're still supposed to at least test it in the field, so,
Oh, come on. Oh, come on.
okay. So, well, let's do this first. So, are you John Charles Davis? Okay. So, Mr. Davis, let's talk about the one that's a little bit harder for your attorney to discuss with me, because there's not much we can do on that one. That's the 2022 CF 4382AO. That's out of Division 10. Looks like Judge Bleckman issued a capias when you failed to appear for a pretrial on November 1st of last year. Those two counts, he set your bond at none. That one, we'll get in touch with your public defender, I think it was Danielle Ashley, see if we can get you a bond hearing in front of Judge Bleckman. On the second case, They're correct. I don't show that the suspected drugs were tested. Does the state want to go back and ask him to do it? You okay with an ROR on this one? Okay. So the good news is, on this case, 2023 CF 1290AO, I will go ahead and issue a straight ROR, so you're released on your own recognizance. I'll appoint the public defender's office to represent you. So they'll just need to get you back in front of Judge Blackman on the other case, otherwise you would be able to get out. Okay?
You have an FTA. So you're to appear. Tell the attorney. Doesn't matter why you feel it, she can't change it.
Okay, Michael Jean-Pierre.
I will waive, Your Honor.
Okay. In 2023 CF 1303AO, I am finding probable cause. I'll appoint the public defender's office. They're gonna waive his appearance. We'll keep bonds stayed at 1,000, 1,500, and 500. This should be Raymond Lee Kelly.
Ms. George?
Mr. Kelly, is your date of birth March 16th of 1987?
Oh, they did.
Yes. Okay. So you are here on case number 2023 CF 1304AO. I have reviewed the charging affidavit in this case. Is this the one that you were questioning?
Yes, it was, Your Honor.
Okay. So I do find probable cause for the possession of methamphetamine, the resisting without.
I think there's a PC for everything other than the.
So I thought this was the one where he said he provided the following information to Officer Velez, that his name was Samaro Lanier, date of birth November 30th of 1990.
I don't, but if you see it, Your Honor, that is all that counts.
It's in the the third paragraph, starting with the bicycle stop.
Yeah, that one.
Then it says he provided the following information to Officer Velez, Samaro Lanier, 11/30 in 1990.
Right.
Oh, yes, okay, then, no issue.
Right. I believe the other one didn't have it, but regardless of the fact, Your Honor, I'm okay with the PC.
Okay, so I am going to appoint the public defender's office. This is in Division 20. I'll stay the bond at 15,000 on count 1, 100 on count 2, 100 on count 3, and 150 on count 4. He is currently out on bond on case number 2022 CF 11572AO. It's an October arrest for grand theft. The state still hadn't filed on it. My inclination was because the 15,000 on the count 1, that I would just take no action on the out on bond.
No objection.
Okay, so Mr. Kelly, you have bond. You are able to get out. Good luck to you, sir. Thank you. Joshua Gabriel Mendez.
Yes, ma'am. How are you? God bless you.
Thank you, sir. You're here on case number 2023 CF 1287AO.
Yes.
The only question I had was, and this is not for you, this is for the state, was the assault on, well, actually, so I have a couple things, actually.
See, that's what I was just talking.
Ma'am, may I say something?
No. Hold on. Hold on. So if you read the report, and this is just me being kind of picky and annoyed at OPD. So it says, I, Orlando Police Officer D. Mejia, and my field training officer, A. Bracente, whose father is a law enforcement officer with Orange County Sheriff's Office. But if you read then it says down here, everybody that signed to it and swore to it was Danny Centeno. Where did Danny come from?
I don't.
Well, Your Honor, this is essentially what happened yesterday with that domestic violence, is that it's, officers are listed within the report, but it's someone else who signs it. And I want to say it was actually this officer who signed that report yesterday. I don't know if this is something internal to OPD. If you want, I can try to clarify.
Oh, no. I see what you're saying, because then he starts talking about, Oh, you know what? I figured it out. If you look, Officer D. Mejia is badge number 37310.
Yes.
Danny Centeno is 37310.
Ah, okay.
And what confused me is when you get down to the third to the last paragraph, it says after battering Officer Mejia Centeno. I
Ah.
think it's because he's got a hyphenated name and he's not using it. So, okay, so I don't really have an issue with that, and so therefore I don't necessarily have an issue with the PC on the bat Leo, the resisting, mischief, or drug paraphernalia. I just have the threatening a law enforcement officer. How does he have the ability to carry through with that while he's in the back of a patrol car in handcuffs?
Well, he does say if I get these cuffs off, Your Honor.
But I think you're supposed to have a well-founded fear that that could happen. Unless I purposefully take the handcuffs off of you and let you try to beat me up, how would that happen?
Well, he said when he gets out. It's when he gets out and if I get these cuffs off.
Was that your issue? Or no, you saw something else?
I was talking about the criminal mischief. I never saw, I mean,
Oh, I thought the criminal mischief.
it was an attempted criminal mischief. I never saw that before. That's why I was asking the state.
I just thought the attempted criminal mischief was kicking the door of
I never hit
the-
nobody.
Could you
Patrol car?
be
I'm sorry.
quiet?
I never hit nobody.
He
It just said,
He says he was sitting in my patrol vehicle. He became manic and started kicking the door several times, attempting to cause damage to the door.
oh, okay.
I agree with you. I assume that that's where
That's
that
what it
came
is,
from.
okay. As far as the threat to a Leo, Your Honor, it was my understanding that the threatening to the officer was sufficient. I haven't, for PC purposes, I am gonna pull the,
Well, let me ask you, was the state, so the other case he's currently out on bond for is 2023 MO 102AO. It's a January 18th arrest. He bonded out on the 19th. It looks like he was general penalty provisions. It looks like he was trespassing on a condemned property.
Yes.
my God.
My intent was really to take no action on that one.
I'm fine with that, Your Honor.
Okay, so he's gonna get a bond. So, Mr. Mendez, here's the way I look at
Can I
it.
say something since you've been talking the whole time? I'm sorry.
You feel free to tell me anything. It just may get you in a lot of trouble.
Your Honor.
I'm sorry.
For 2 seconds before
Yes.
you start speaking.
I'm on pre-trial release. I never had a bond, though. I never paid for a bond.
Go ahead and talk. I'm done. I can't.
What would you like to tell me?
Oh, Jesus.
I would like to say, why are they saying that I have bond when I never had a bond? I never bonded myself out when you guys let me out on the 24-hour time served. There was more people involved in this.
There was no time served. You were ROR.
Sir, I have you currently out on bond, and by bond,
Yes.
your bond is an ROR. You were released on your own recognizance.
Yes.
So that's why you're being held here with no bond, is because you're currently out
Oh.
on another charge.
So I would have had PTR today if I didn't have that RR, correct, ma'am?
No, not necessarily. No, they're just holding you. So let's say, for example, you got arrested for the exact same charge.
Yes, ma'am.
I have the ability to revoke your ROR and hold you at no bond. But we went ahead and said that because that was a misdemeanor and it's about a trespass charge, we're not going to take any action.
Thank
So
you.
you're going to get a bond.
Thank you. God bless you.
Okay, well, don't God bless me yet, because you're not going to like the next part that I'm telling you.
Okay.
So this is the way that I look at this, Mr. Mendez. When you start threatening law enforcement officers, and this is because I'm married to a police officer, when my husband comes home and tells me that somebody's threatened him, they're in handcuffs. So my theory is what could you really do about it? And I don't want you to say anything to me, but the theory is if I go out and I'm at Walmart and I see you, my husband's probably gonna try to shoot you because you've already threatened him. So be careful when you make threats like that.
Okay.
Because I don't know necessarily that the threat was something that you could take advantage of while you're in the back of a police car. But when you say, when I get out, I'm gonna do this, it makes the cop very wary that if he sees you, and you make any furtive movement towards him, that could be the end of you.
Yes, ma'am.
So what I'm gonna do, sir, is on count one, I'll keep the bond set at $2,500. Count two is $150. Count three is $100. I'm gonna ROR you on counts 4 and 5, and your bond will be $100 on count 6. We do have the public defender's office appointed, and this is in Division 22 with Judge Harris. Okay, good luck.
Your Honor, are you saying then that you don't find PC?
I'm not finding PC on those two counts. Is that him?
Yes.
Really? No PC?
Okay. Okay. Based on that little outburst, I'm just gonna no bond him because I think he's clearly a threat to a lot of people.
I'd ask that you revoke the out on bond so that, because
Okay.
he's entitled to a bond on the new one, so just revoke the out on bond.
No. Okay.
That way he can't go.
Somebody needs to do something with him before he hurts himself or somebody else.
They're doing it now.
Okay. Wow, that's fun to see. Okay, so I will go ahead and tell you what I told you before, 2,500, 150, 100. How about let's just go with 100 and 100 and 100, because he clearly has some violent tendencies. And then because he's currently out on bond on case number 2023 MO 102 AO, I am gonna revoke that ROR. I'll hold him at a no bond. I didn't look to see if he had the public defender. I'll appoint the PD if he doesn't.
Yes, Your Honor.
Okay, perfect, thank you. Somebody really wants to talk to him. Okay. No, probably nobody wants to talk to him. Alexander Mess.
Bonded, Your Honor.
He bonded, thank you. How about Crystal Odom? Miss Odom's like, please keep me away. Okay.
Okay.
Miss Odom, you are here on case number 2023 CF 1280AO. I'm gonna go ahead and appoint the public defender's office to represent you. I'll keep your bond set at $1,000 and you're all set.
Okay, be RR.
No, you don't qualify for ROR, unfortunately, so, okay.
Okay, thank you.
Thank you. Thomas William Ritter,
He refused.
okay,
I will waive, Your Honor.
okay. In Mr. Ritter's case, this is 2023 CF 1276AO. I am finding probable cause. I'll appoint the public defender's office and I'll stay the bonds at 3,500 on count 1, 100 on count 2.
No return?
No return, yes, sorry. I knew I heard that somewhere, sorry. Hayden Turner. And Mr. Turner, is your date of birth September 27th of 2003? Okay. Okay. So, Mr. Turner, I did review the charging affidavit in this case. I am finding that there's probable cause. I'll appoint the public defender's office to represent you. This is in 2023 CF 1291AO out of Division 15. I will set your bond in the amount of $1,000. Okay, good luck to you, sir. Thank you. Keandre Ladarius White. Hi, good afternoon, Mr. White. Is your date of birth January 21st of 2000?
Yes, ma'am.
Okay. So, sir, you're here on 2 charges. I did review the charging affidavit in this case. This is 2023 CF 1294AO. I'll go ahead and appoint the public defender's office to represent you.
Your Honor, I believe.
He does qualify for
Qualify
pretrial
for
release.
Your Honor. I would ask for pretrial release, Your Honor.
Okay. So, Mr. White, I will go ahead and release you on a straight pretrial release, so you don't have to bond out, but the conditions are that you're not to possess any weapons or firearms or any illicit substances.
Can I have a moment, Your Honor?
And how about we just give him 30 days before we test him?
Thank you, Your Honor.
Tarvis Williamson?
Yes, do you guys have a plea or I can get a pretrial release?
Well, let's get to one thing first. Let's see. So wait a minute. I've got Kevin Maurice Williams. So you are Tarvis Williamson?
Yes, Your Honor.
Were you born March 22nd of 1990?
Yes, Your Honor.
Okay. So I have Kevin Maurice Williams. Did we pull out?
Yeah.
That was a move up.
Thank you. Okay, perfect. So, no, sir, you're not going to qualify for pretrial release. That being said, though, I do show he is currently out on bond in 2022 CF 13509AO. It's a charge of criminal mischief. I know it hasn't been filed on yet since he just bonded out December 22nd. I wasn't going to take any action on it unless the state was.
No objection.
Okay. So good news is you're being held on no bond, but I'm going to take no action, and then that will take that away. So you're able to bond out on this new case, which is the 2023 CF 1288AO. I'll set your bond at $1,000, and we'll appoint the public defender's office, okay?
Yes, does the state have an offer?
I don't know that they'd have an offer this soon.
Oh, okay, I apologize.
Okay, no worries, thank you. The last case I had was Brandon Wolf. Misbehavior. Okay. Maybe put him next to that other guy.
I will waive, Your Honor.
In 2023 CF 1283AO, I am finding probable cause. I'll appoint the public defender. They're waiving his appearance, and we'll keep his bond set at $1,000. Well, that was exciting. That was everything for today?
Yes, Your Honor.
Okay. We'll be adjourned until tomorrow morning at 9. Yes? Is that your name?
Paulino Dias.
Hi, good morning. This is Judge Martha Adams.
Hello, Your Honor. My name is Reynaldo. I'm the Portuguese interpreter with Language Line Solutions. My ID is 374872.
Okay. Good morning, sir. I do have a case here with two people. One is the defendant, one is his wife. They both need the services of the interpreter. So because of that, it's going to maybe take a little bit longer, but we'll go slowly. First, I'm going to talk to the wife. And ma'am, can you just tell me your name again?
Alô, senhora, eu vou ser seu intérprete. Ela está pedindo para você falar o seu nome de novo, por favor.
Lucélia Fernandes.
Say that one more time.
Você pode falar mais uma vez, por favor?
Lucélia Fernandes.
Okay. And Ms. Fernandez, I am confirming that this is your husband and you've been married for 2 years. Is that correct?
Tá, senhora Fernandes, e eu estou confirmando que este aqui é seu esposo com quem você tem estado casado há 2 anos, correto?
Sim.
Yes.
And This case was reset to today to give the state additional information, for the state to get additional information.
Tá, então, esse caso foi recolocado para o dia de hoje para dar a informação adicional para o Estado.
My understanding, the state was unable to get that additional information. Is that correct?
Eu entendo que o Estado não conseguiu pegar essa informação adicional, é correto?
That is correct, Your Honor.
É correto?
Não entendi.
She's saying that she did not understand.
So, ma'am, it just means that I'm going to release your husband on his own recognizance. That just means that he doesn't have to provide any bond to get out of jail. My only...
Então,
Go ahead, sorry.
então, isso quer dizer que eu vou liberar o seu esposo baixo o reconhecimento dele. Ele não vai precisar prover uma fiança para sair da cárcere.
Obrigada.
Thank you.
And I don't know if the other judge spoke to you yesterday about this, but were you wanting to have contact with your husband? Did you want him to come home with you?
Eu não sei se o outro juiz conversou com você em relação a isso, mas você quer ter contato com o seu esposo? Você quer que ele volte para casa com você?
Sim, eu quero ter contato, tanto ele comigo quanto com os nossos filhos.
Yes, I do want to have contact, me, and I want him also to have contact with our children.
Okay. So, I will issue an order that says that you're not to have any hostile contact.
If we're finding no PC and RORing him, I don't believe you can put conditions since we didn't find probable cause.
That's true. How about I just suggest it? It's a good idea.
Yes, Your Honor.
Okay. So, I'll let the interpreter interpret. So at this time, he's going to be released on an ROR, and I'm just suggesting no hostile contact.
Tá, então, nesse momento, ele vai ser liberado baixo a ROR e vamos sugerir que ele não tenha contato hostil.
No caso, ele não vai ter contato hoje ou não vai poder ter contato com a gente?
So in that case, will he not have contact today, or he won't be able to have contact with us?
No. He's going to be released, and you guys will be able to go home and stay with each other.
Não, então ele vai ser liberado e ele vai poder ir para casa e ficarem juntos, tá?
Obrigada.
Thank you.
Hold on. Can I just ask a question? Because I don't want to disrespect Judge Strobridge, but don't you have an independent witness that says that he slapped her in the face with an open hand?
I think the issue, Your Honor, as it was explained to me, as there is one officer that is mentioned within the affidavit, but it was another officer that actually signed the affidavit. So I think there was, right.
Okay. I won't question it then. Ma'am, you are free to go, and you can pick up your husband. The COs will tell you how to do that, okay?
Muito bem, senhora. Então, você pode ir e você pode pegar seu esposo. Eles vão te falar como você pode fazer isso, tá?
Obrigada, muito obrigada.
Thank you.
Okay, thank you. Good luck, sir. Thank you. Thank you, interpreter. I
Obrigado.
appreciate
Boa
your
sorte.
help.
You're welcome. Is there anything else I can help with?
No, sir. Thank you so much.
Okay, you're welcome, Your Honor. Thank you for using our services. Bye-bye.
Bye-bye. Okay. So this should be Sincere Lee Dupree.
Yes, ma'am. Yes, ma'am.
Mr. Dupree, let's get readjusted here. Okay, you're here on case number 2023 CF 129980. This is out of Division 14. I am going to go ahead and appoint the Public Defender's Office to represent you. Sir, I will go ahead and I'll set the bond at $2,000 on count one, $150 on count two. I am going to order that you maintain a separate residence from your girlfriend. Obviously, wherever that may be, that just needs to be separate from her because I am going to issue the no contact order. That means you're not to have any contact with her whatsoever. The document that you signed is just acknowledging, did you have him sign that before? Yep, you signed it already. That's just acknowledging that you understand what that means. Is there possibly anything in her tent that belongs to you that you need to get?
Yeah, about 50% of the stuff is like mine.
Okay, so I will allow you to return one time with law enforcement officers so that you can retrieve any belongings that you may have. I am going to order that you not possess any weapons or firearms, and you're all set, okay? Good luck to you, sir. You have a question?
Is it possible maybe to get the bond maybe a little bit more cost effective for me? Because I have, a lot of my stuff got damaged yesterday from work, and I was wondering if there's any way to have it more minimized.
Your Honor, I was going to ask for it to be raised considering that 2 days prior, he beat up the same victim.
200.
Yeah, I was going to say, I think we're pretty lucky that I left it at 2,000. So let's leave it like that. Okay, good luck to you, sir. Thank you. Christopher Kallage? Is that you? Is it K-A-L-A-G-E?
Correct, and good afternoon, good morning, Your Honor.
Good morning. And how do you say that, sir? Kallage?
Kalaji,
Okay, thank you. And Mr. Kallage, I just want to verify you were born on May 31st of 1953.
correct.
Okay. So, sir, I have you here on case number 2023 CF 1300AO. Are we already that high? Or is it just 300? We're already at 1,300? Wow, Jesus. Okay, sorry. So, Mr. Kallage, I did review the charging affidavit. I am finding that there's probable cause. I'll go ahead and appoint the Public Defender's Office to represent you. Now, obviously, without your roommate here this morning, I do have to issue a no contact order between the two of you. The document that you signed with the CO, that was just acknowledging that you understand that, that no contact order. You have someplace else you can stay?
She doesn't live in my house, that's my house, she doesn't live there.
She has no belongings there?
She has some belongings there because she was at a shelter and they were in a warehouse, and she was paying the money for nothing. So
Well, let me ask you-
She asked if she could bring them over. I said, sure.
Well, let me ask you a question. Does she have a key to get in the house?
The key? No.
She does not have a key to get in the house. Does she get any mail there?
No, her driver's license is registered to her sister.
Okay, that's perfect. Then what I'm gonna do, sir, is I'm gonna release you on a straight pretrial release, so you don't have to pay any money to get out of jail. The only conditions are that you maintain a separate residence from her, the no contact order, that you not possess any weapons or firearms,
None.
and that you not possess any illicit substances while you're on release.
No.
Okay? Okay. Good luck, sir.
Your Honor.
Thank you.
Thank you. Now, where do I go from here?
They'll take you. Perfect. Thank you.
That's you.
Again, thank you.
You're welcome, sir. Good luck. Jacqueline Otero Nazario? Okay. I don't understand why they can't just even put like a little dash in there between the last names. When you just smush them all together, it's very confusing. Okay, so Ms. Otero. Ms. Otero, your date of birth, November 10th, 1974?
Yes.
Okay, so you are here on case number 2023 2023 CF 1277AO. This is in Division 14. I am finding that there's probable cause. I will go ahead and appoint the Public Defender's Office to represent you. Without your former boyfriend being here this morning, I do have to issue a no contact order between the two of you. That means you're not to have any contact with him whatsoever. Obviously, that's going to mean that you need to maintain a separate residence from him. Do you have someplace else you can stay?
Yes, ma'am.
Okay. I will allow you to return one time with law enforcement officers so that you can retrieve any belongings that you have. I'm also going to order that you not possess any weapons or firearms, and I will go ahead and set your bond at $1,000. Okay? Good luck to you, ma'am. Thank you. Catherine Odalis Acosta Lopez?
Yes, Your Honor.
And Ms. Lopez, or Acosta, were you born on July 19th of 1997?
Yes, ma'am.
Okay. And you are here on case number 2023 MM679AO. Is this Ms. Rosado? What's your name?
I'm Jamie Acosta. I'm her sister.
Okay, and how are you related to her?
She's my sister.
She's your sister? Okay, let me get you to raise your right hand for me. Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, and I apologize. Tell me your name one more time.
Jamie Acosta.
Acosta, okay. Now, Ms. Acosta, I have read through the charging document in here. I don't think I see your name. Were you present during any of this?
Yes, I was.
You were, okay. Did I just miss that? Okay. Did you, what was it that you wanted to tell us while you were here today?
I just want to know if my sister is going to be able to go back home.
So part of the problem is that Hamon is not here because that's the no contact order that I have to issue. Without him being here telling me something differently, that means she's going to have to stay someplace else. Is it possible that she could stay with you? Do you live with her?
No, she's the head of the household of the house. He just stays there.
Okay, but I'm saying, do you live at that same location?
No.
You live someplace else. Is it possible she could live with you until this kind of gets sorted out and resolved?
Yes.
Okay. So, I am finding that there's probable cause. I'll appoint the Public Defender's Office to represent you. I do have to issue that no contact order, but what you can do is you can get your attorney to get with the trial judge and change those conditions. But until then, you really need to stay with your sister and stay away from him. I will allow you to return one time with law enforcement officers so that you can retrieve any belongings. I am going to order that you not possess any weapons or firearms. DCF was notified, so if they put any parenting plans into play, I would like for you to abide by that. But most importantly, I am going to go ahead and release you on pretrial release. That way you don't have to post any monetary bond to get out. You'll just be supervised by pretrial services. And then you should be able to pick her up very shortly, maybe like in an hour or two.
Okay. Is she able to pick up her daughter?
So let me ask you a question. The children that you have, they're both your daughters, but one is his stepdaughter and has nothing to do, it's not biologically his, right? And that's the 8-year-old? Okay. Is that the one that you're talking about? Or are
No,
you
I'm
talking about the 1-year-old?
The 1-year-old.
That's going to be entirely up to DCF. Has DCF contacted you while you were here? No? You're just going to need to abide by anything that they've put into play. My concern is that if he's with his dad, and yeah, it's possible that she may not see the 1-year-old, only because of what's going on, but it is possible that the 1-year-old could come back. I would just abide by anything that DCF puts into play. Okay?
Okay.
Anything else?
No.
Okay, okay. Good luck to both of you. Thank you. Antrell Bryant? Okay, good morning, Mr. Bryant. Is your date of birth December 18th of 1991?
Yes, ma'am.
Okay, thank you. So, Mr. Bryant, you are here on case number 2023 MM66580. I did review the charging affidavit. I am finding that there's probable cause on that case, and I will go ahead and appoint the Public Defender's Office to represent you. Let's do this. You also have another case, a 2021 CT 8154AO. That is a capias that was issued when you failed to appear. It has a $1,000 bond on that. I'll go ahead and appoint the Public Defender's Office on that as well if they were not previously appointed. So going back to the battery charge, you understand that without Ms. Stearns being present here today, I do have to issue a no contact order between the two of you. That means you're not allowed to see her, call her, text her, email her, have any contact with her. Now, obviously, you may want to change that down the road, but the only person that can do that is the trial judge. In this case, that's Judge McGinnis. So you would need to get with your public defender to have a hearing in front of him so that he could change that. Do you have someplace else that you can live for right now?
Yes.
Okay. So I'm going to go ahead, yeah, because you and Miss Burns don't live together anyway, right?
No.
Okay, perfect. It's hard when sometimes the police officers write this. So, sir, I'm going to go ahead on the battery charge. I'll give you a $500 bond, the no contact order, the maintain separate residence, no weapons or firearms. Do you have anything at her house that you need to get?
No, we don't stay with each other. Everything at my mom's house.
Okay, I just didn't know maybe like if your car was there or
No,
your phone or.
there's nothing there.
There's nothing there?
Yes.
Okay, then you're good to go.
Yeah. Okay. So that's all right. Thank you.
Okay, thank you, sir. Gil Alejandro Cardona Flores. Good morning, sir. Is your date of birth October 23rd of 1998?
Yes, ma'am.
Okay. And I believe this should be Keisha Hernandez?
Yes, Your Honor.
Okay. Ms. Hernandez, can I get you to raise your right hand for me? Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay. So, Ms. Hernandez, I think you've heard by now that normally I issue no contact orders. Was this something that you were agreeing to, or did you want me to do
Yes,
something
ma'am.
differently?
No contact, please.
You're agreeing to the no contact?
Yes, Your Honor.
Okay. And I was a little confused, and maybe the state or the PD can help me. I'll go ahead and appoint the Public Defender's Office. The way that he wrote this, is he just saying that he'd filed the charges at large and now he was just taking everything and filing it? Is that how you read that? It was kind of confusing.
I apologize, Your Honor. I skipped down to where the contact actually happened.
Because it just says this is a supplement to the original report that was already submitted under the same case number.
Oh, I think what it is, Your Honor, is this was written yesterday because I guess we encountered
him.
each other, but it was from Friday.
Gotcha.
Yes.
Okay. Okay.
Oh, the 27th, yeah.
Okay, so, Mr. Cardona, I am gonna go ahead and I'm noting that there is probable cause on the case. I'll appoint the Public Defender's Office. This is in Division 50. I am issuing a no contact order between you and Ms. Hernandez. That means this is the last time you're gonna be able to, well, not even now, but you can't talk to her, you can't text her, email her, anything like that. If you violate that order, you do run the risk of coming back to jail. Is there anything at her house that belongs to you that you need? Yes?
No, they picked it up this morning.
They picked it up, and when you say they, who do you mean?
His friends.
His friends?
His friend and his mom.
I don't personally know that, so I would still like to go with the officer and make sure that all my things were removed.
Okay. So what I'll do is it sounds like all of his stuff is gone, but just in case, if he figures out that there's something left over or you see that there's something left over, I will allow him one time to return with law enforcement officers to retrieve any belongings. I'm gonna order that you not possess any weapons or firearms. And I think you're all set. Was there anything else you wanted me to know?
Is the no contact order just for him? Because his friends came to my house this morning and this past weekend as well.
So the no contact order is between the two of you, but it also applies to any third party. So you can't have, I understand your friends and your mom came to get your stuff, but after today, they can't have any contact with her either. Because the theory is they're not supposed to have any contact on her, on your behalf. So unless you just happen to be friends with them, that would be different. But if they're purely there because they're his friends, that sounds like that's,
The friend, they're her friends.
They
Okay.
were my friends,
they,
but I met them through him. So technically, they're his friends.
okay. My guess is maybe she doesn't want to hang out with them anymore. So that'd be good. They'll go back to just being your friends. Okay. Anything else, ma'am?
He's also been harassing my friend as well. And he wrote a statement as well towards him. That's on Friday's case.
Because I don't have any criminal charges with them as the alleged victim,
It's just through me.
yeah, it's just for you, but please contact the state attorney's office. They have victim advocates. You can also file injunctions down at the courthouse, Harbor House. has-
Yes. Can I do that today?
Yes, ma'am. If
Okay,
you go down to they're on the 5th floor, I think. Do you know where Harbor House is now?
I have the information.
They're on the 5th floor, yeah. And there are attorneys that are there that can help you, as well as their advocates.
Thank you, Your Honor.
You're very welcome, okay?
Your Honor, I don't think you've given an amount for bond.
I thought I said 500. If I didn't, I apologize.
Your Honor, I don't remember a bond amount.
$500.
Thank you.
Okay, anything else, sir?
You're welcome.
Okay, are you Vincent Dones?
Yes, ma'am, don't ask.
It's Dones? Thank you. And so were you born on September 8th of 1990?
No.
Okay. You are here on case number 2023 MM659AO. This is assigned to Division 50. I am finding that there's probable cause. Mr. Dones, without Ms. Williams here this morning, I know she certainly indicated that she was not wanting to cooperate with law enforcement officers, but unfortunately, without her being here this morning, I do have to issue that no contact order. That being said, keep in mind, you're the one that possesses it. So if you come into contact with her, you're the one that's likely to go back to jail. So if you think she wants to change that, get with your attorney so that you can get in front of Judge McGinnis to change that. Is it my understanding, you guys have been together for 5 years. Are you living together? Okay, so I'm just gonna include with the no contact order that that you maintain a separate residence from her. Is there anything at her house that you need? Okay. I'm also gonna say that you're not to possess any weapons or firearm. And, I am gonna go ahead and set your bond in the amount of $500, okay? Good luck to you, sir. Thank you. Are you, yes, Estevez?
Just Estevez, yes, ma'am.
Mr. Estevez, were you born on October 14th of 1985?
That is correct, ma'am.
Okay. So, sir, I did review the charging affidavit in this case. I am finding that there's probable cause. I love the officers that want to give Marcy's law, but then they leave out the part that's important. Is it my understanding that you and the alleged victim are husband and wife?
That is correct.
Okay. How long have you guys been married?
We've been married since 2018. We've been together since 2012.
Okay. And, okay, so what I'm gonna do, sir, is you do qualify for pretrial release, so I don't have to release you on a monetary bond. We can just release you through pretrial services. Without your wife being present here today, though, I do have to issue a no contact order, obviously.
So how does that work with my house? The house is the only place I can go to. I have no other family here.
You don't have any friends?
I don't have friends like that. I literally work and go home and support our 9 kids. My wife doesn't work. I'm the one that works.
Okay, well, you may have to stay
so
in a
then I won't
hotel
pay
or
the
something.
bills then.
You won't what?
I won't be able to pay the bills if I'm not staying in that home.
Okay, well, that's something that you're gonna have to talk to your attorney about.
Okay.
Unfortunately, the problem is I have to issue the no contact order, and if you're the one that has contact with her in any way, you're the one that's gonna end up back in jail.
Yes, ma'am.
So I would talk to your attorney.
I'll just stay at my tattoo shop, if anything.
Okay. It's probably not the most comfortable, but at least it's safe and
be all
you're
right
good.
then. Yeah.
Now, like I'm saying, Judge McGinnis has the ability to change this, but you do have to get back in front of him to do that.
Okay.
So, if you have any belongings that you need at your home, I'll allow you to return one time with law enforcement officers so that you can retrieve those belongings.
What happens to my animals?
Do you not think she'll take care of them?
No.
Do you want to take them to your tattoo shop?
I have 9 of them. I can't do that.
Children or animals?
I have 9 children and 9 animals.
Each one could take care of an animal or no? Just
Maybe if you put it on the court order, she'll do that.
I can do that. I'll let you and your attorney figure it out. I'm sorry.
No problem.
I don't-
Thank you.
Yeah. No weapons, no firearms. Oh, and I do believe DCF may have been contacted, so you just need to abide by any plans that DCF puts into play.
Sounds good.
Okay. Good luck to you, sir. Thank
you.
you.
So I'll be released without do I not have to pay a bond?
You
or
don't
how-
have to pay a bond. You'll
Thank
just
you.
be released to pretrial services. Let me ask you a question.
What is pretrial services?
They're the people that came and talked to you earlier about like, did you have community ties? They ran your business and stuff like that. Do you remember talking to them?
No.
No? Okay, doesn't matter, but it's just them. But let me ask you a question. I appointed the public defender's office to represent you. Did you want them to be appointed? Are you
For
gonna-
now, yes.
Okay, if that changes and you hire your own attorney, they can just come off the case after that.
Understood.
Okay, good luck, sir.
Thank you, ma'am. You have a wonderful day.
You too. Okay, Isaac Gutierrez. Mr. Gutierrez, I have 2 cases here. Actually, I have more than that. Or just do I have two copies of the same thing, maybe? Okay, so it goes like that, though. Okay, that was just all that was confusing me, so. Okay, so, Mr. Gutierrez, you are here on a couple cases. The new charge is out of 2023 MM 674AO. I am finding that there's probable cause. You understand without the alleged victim being here this morning, that I do have to issue a no contact order between the two of you. That means no contact, no contact. It's my understanding, let's see, Eli. So do you have someplace else that you can stay?
Yes, Your Honor.
Okay. So what I will do, sir, is, I'll appoint the public defender's office. I'm gonna set your bond in the amount of $500 on the battery charge with the no contact order. If you need to retrieve any belongings, you may do so one time with law enforcement officers. I'm also gonna order that you not possess any weapons or firearms. As to the out-of-county warrant, that is, hold on. Based on you being on state probation out of Hillsborough County. So the bond on that has been set at none. I will temporarily appoint the public defender's office to represent you. The Hillsborough County has the ability to come and pick you up. If they don't do it within a certain amount of time, you can talk to your probation or your public defender and they'll try to get you a bond hearing, but hopefully you'll be transported within the next couple days. Okay, good luck to you, sir. Thank you. Maurice Harrell? Are you Mr. Harrell?
Yes.
Okay. Mr. Harrell, were you born on February 23rd of 1982?
Yes.
Okay. Sir, you are here on case number 2023 MM 35AA. This is a battery charge. I am finding that there's probable cause. It is assigned to Division 50. And sir, I will go ahead and appoint the public defender's office to represent you. Based on the fact that the alleged victim is not here this morning, I do have to issue a no contact order between the two of you. That's the order that you signed. It's just acknowledging that you're aware that no contact means you're not to see her, call her, text her, email her, have any contact with her in any way. Now, it's my understanding the two of you do not live together, correct?
Right.
Okay. Do you have anything at her house that you need, like any, like?
I need to get my shoes and stuff.
Okay. So I'll go ahead and put that you can return one time to her home with law enforcement officers to retrieve any belongings that you might need. I am just going to order that you not possess any weapons or firearms. Now, you do qualify for pretrial release, so I will go ahead and release you on pretrial release so you don't have to pay the monetary bond to get out of jail. It's just the conditions with the no contact, the one time with law enforcement, and no weapons or firearms. Do you have any questions? Okay, you're all set, sir. Good luck to you. Thank you.
He said he didn't want any. That's what it said.
Okay, good morning, sir. Are you Kashif Hassan?
Yes, ma'am.
And Mr. Hassan, were you born on December 14th of 1985?
Yes.
Okay. Have you been able to verify?
His fingerprints have cleared. He does qualify for PTR, Your Honor.
Okay. So, Mr. Hassan, we're here on 2023 MM 667AO. I am finding probable cause. This case is assigned to Division 50. And sir, I'll go ahead and appoint the Public Defender's Office to represent you. Without the victims being present here today, I do have to issue a no contact order. That order that you signed previously is just acknowledging that you understand that you hold the order, meaning that if you violate that order by having any contact with either victim, you do run the risk of coming back to jail. That being said, I believe it's my understanding that you do live with Stephanie, correct? Okay, so I'm gonna put that you're to maintain a separate residence from both of the victims. If you need to retrieve any belongings, you may do so one time with law enforcement officers, and you are not to possess any weapons or firearms. Do you have any questions?
What about my 3 kids?
I'm sorry?
Kids?
Oh, the kids. That also reminds me, if DCF gets involved, you do need to abide by any plan that they put into place. Because the children are currently with your wife, I think they're gonna be a part of that no contact order. But that being said, if you get with your attorney, it is possible that you could get Judge McGinnis to change that, but it would just need to be done with a separate hearing.
Gotcha.
Okay, okay. Good luck to you, sir. Thank you.
Was it PTR, Your Honor?
Yes, straight pre-TR. Mary Elena Hernandez?
Yes, ma'am.
Ms. Hernandez, were you born on March 19th of 1997?
Yes, ma'am.
Okay. How about her prints come back?
Her prints are back, Your Honor. She didn't qualify, though.
No, okay. So, Ms. Hernandez, I have reviewed the charging affidavit in 2023 MM36AA. This is assigned to Division 50, and I will go ahead and appoint the Public Defender's Office to represent you. So, Ms. Hernandez, is it my understanding that you and Mark live together at your home, right? Because he's your brother?
He's sometimes there, sometimes not.
He's sometimes there, he's sometimes not? Okay. Well, what I'm gonna do is, I am gonna set your bond in the amount of $500. I'm gonna order that you have no contact with your brother. The order that you're signing is just acknowledging that that order is in place. Obviously, he's your brother. I can't imagine that you're not gonna talk to him for the rest of your life. So it is possible to get that in front of Judge McGinnis and he can change it, but it usually requires your brother to be present. So right now, it's just saying that you're not to have any contact with him. If you go home and he is not there, you're more than welcome to stay at your house. If he is there, you're just gonna have to find someplace else to stay. Do you have a friend or somebody you could stay with until you get back into court?
Possibly like my aunt.
Okay. Hopefully, they'll be able to work that out with you, I'm sure. The only other condition that I will include is that you not possess any weapons or firearms, okay? Can you sign that order for me? It's just acknowledging that you're... Oh, yeah, if he is there, I will go ahead and put that you can return one time with law enforcement officers so that you can retrieve any belongings. Okay, good luck, ma'am. Thank you. Samantha Mary Hutt?
She's medical.
Okay.
I will waive, Your Honor.
Okay. On Ms. Hutt, I will go ahead and this is 2023 MM37AA. Assigned to Division 50, will appoint the Public Defender's Office to represent her. They're going to waive her appearance. I am going to order that she is not to have any contact with the alleged victim in this case. Live in the same place. Don't they? 500. Yeah, they live together. So, she is to maintain a separate residence from the alleged victim. I'll allow her to return one time with law enforcement officers so that she can retrieve any belongings, and she's not to possess any weapons or firearms. I'll keep the bond set at 100 on count 1 and 500 on count 2. This should be Jay Franklin? Okay, Mr. Franklin, good morning. Were you born on March 15th of 1990?
Yes.
Okay. So, sir, this is a violation of probation that was signed by Judge Calderon. He has set your bond at none. This is in Division 12. Oh, that's on 2021 CF 6652AO. There is also a new case, which is 2023 CF 1286AO. I am finding that there's probable cause, and I will stay the bonds. 15,000 on count 1, 150 count 2, 100 count 3, and 150 on count 4. And the Public Defender's Office is appointed to represent you. Okay, good luck to you, sir. Thank you. Do these? Okay. Yeah, I still gotta talk to Monday about this. Yeah, because these could easily be done someplace else. They're just, I mean, it's just, we're just like chatting. So, anyway. Okay, you ready for the 33 days?
Yes, Your Honor.
Okay, so the first case I have is Anthony Albert, 2022 CF 14912AO.
Granted, notice of non-filing.
Today's the 30th. Anthony Ray Albert has a second case, 2023 MM3AO.
Denied, information was filed.
Stacy Hightower, 2022 CF 14933AO.
Granted, notice of non-filing.
Matthew John Petrovic, 2022 CF 15061AO.
Denied, information was filed.
Tristan Lee Smith, 2022 CF 14932AO.
Denied, information was filed.
Derek Randall Sperlin, 2022 CF 13360AO.
Granted, notice of non-filing.
Phyllis Omar Taveras, 2022 CF 14878AO.
Granted, notice of non-filing.
Elijah Bakara Thomas, 2022 CF 14899AO.
Granted, case was no billed.
Tyler Kane Warwick, 2022 CF 15009AO.
Denied, information was filed.
Okay, I believe that was everything I had for the 33-day motions. Any left over? No? No. That's it. What do you guys want to do for the rest of the day? Go home? Go have cocktails? The guy at the gate said just no bond to everybody and we could all leave. That's a good idea. Just kidding. Sure. So it's 10:37. Why don't we just say, I'll round up a little bit. We'll do 11:45. Oh, yes, ma'am. Yeah, is that okay, or you want longer? It's up to you guys, whatever you would like. Would you rather do noon? Shoot for noon? Yes, ma'am. Okay, so we'll be in recess until 12 noon. Thank you.
Good afternoon, everybody. This is Judge Arendis. We are here this afternoon for initial appearances. When I call your name, I need you to come up to the microphone. I will ask you to state your name and date of birth and make sure I have the correct person. I will then let you know what charges you have been arrested on, if there's a bond and the conditions of that bond. If we know your next court date, we will let you know. Otherwise, it will be on demand. May I have appearances for the state?
Good afternoon, Your Honor. John Paul on behalf of the state.
Thank you. Pretrial release.
Patricia Jenkins, pretrial release.
Thank you. And for defense?
Rachel Anderson on behalf of the Public Defender's Office.
Thank you. Ms. Anderson, if you have a probable cause challenge, please let me know when I call the case.
Yes, Your Honor.
Thank you. Before I have the interpreter join us, did you have them complete applications for your services yet or not?
Yes, Your Honor. Social Services came this morning and completed applications.
All right. Well, for purposes of today and today only, the public defender is provisionally appointed unless they've indicated that they don't need your services. The applications will need to be reviewed so that the court can determine whether they qualify for future services. So it's only provisionally for today.
Good afternoon. This is Laura Arroyo, State Certified Interpreter and previously sworn.
Good morning, afternoon, Ms. Aurora. This is Judge Arendis. We are in Osceola in courtroom 4E. I am handling initial appearances, so the sound is going through the courtroom over to the jail. Our first case is 2023 MM 219, Freddie Ramos, AKA John Doe 3241. Thank you. Good afternoon, sir. State your name and date of birth, please.
Buenas tardes, señor. Por favor, indique su nombre y fecha de nacimiento. Good afternoon. My name is Jose Fredis. 1980, March 18th.
18 or 19?
18 o 19? 19.
And is your name Jose Freddy or Freddie Ramos?
¿Su nombre es José Freddy o acaso Freddy Ramos?
No, mi nombre es José Freddy Ramos, son apellidos.
My name is Jose Freddy Ramos as a last name.
Thank you. Because you identified yourself as Jose Freddy.
Es que, gracias, pero usted se identificó como José Freddy.
Sí, así me llamo, José Freddy.
That is my name, Jose Freddy.
Sí.
Your full name is Jose Freddy Ramos, correct?
Su nombre completo es José Freddy Ramos, ¿cierto?
Sí, el último apellido es Rivas. Son dos apellidos los que tienen mi identidad de Honduras.
Yes, my last name is Rivas. I have two last names on my Honduran ID card.
I'm just trying to establish that I have the correct person in front of me, sir.
Simplemente estoy tratando de confirmar que tengo a la debida persona ante mí.
Sí.
Yes.
Thank you.
Gracias.
Sir, you've been picked up as a result of battery, simple touch, or strike.
Bien, señora, a usted le detuvieron por un acto de agresión física al golpear o simplemente tocar.
The court has reviewed the charging affidavit. I do find there's sufficient probable cause.
Se ha estudiado el documento acusatorio y determinó que existe suficiente indicios de criminalidad.
You do not qualify for pretrial release due to immigration status.
Debido a su estatus migratorio, usted no reúne los suficientes requisitos para libertad provisional.
Bond to be set in this matter in the amount of $1,000.
En este asunto dado, se fijará la fianza en $1,000.
You are not to return to the church located at 1601 North Ecker Avenue.
Prohibido usted regresar a la iglesia ubicada en la 1601 Avenida Parker Norte.
You're to,
Oh, okay.
You're to have absolutely no contact with Jessica Wooden.
Prohibido ningún tipo de contacto en absoluto con Jessica Wooden.
No contact means no in-person contact.
Cuando le digo nada de contacto, quiere decir no puede tratarla en persona,
no third-party contact,
ni a través de terceros,
no social media contact,
ni a través de medios sociales,
no telephone contact,
ni tampoco por teléfono,
no contact whatsoever. Do you understand?
ningún tipo de trato en absoluto. ¿Entendido? Yes, very well.
You're to maintain separate residences.
Prohibido la convivencia con la víctima.
You're not to possess or consume any alcohol or drugs.
Prohibido la tenencia o el consumo de alcohol o drogas.
You're not to possess any weapons, firearms, or ammunition.
Y prohibido la tenencia de municiones, armas de fuego o arma alguna.
Do we have
Yes.
the next court date?
On demand.
¿Cuándo va a ser la próxima vista? Por notificación.
Thank you, sir. You may have a seat.
Gracias, señor. Ya puede tomar asiento.
¿Puedo hacerle una pregunta?
May I ask a question?
Yes, sir.
Dígame, señor.
Pues, si es grave en mi caso, porque escuché que $1,000 parece de fianza, no sé, por abogado o por qué es $1,000.
Is that the bond in my case? Because I heard something about $1,000. I don't know if that's for the attorney or what it's for.
I said your bond in this matter is $1,000.
Le acabo de indicar que la fianza en el caso de hoy es $1,000.
Está bien, gracias.
Okay, very well, thank you.
Thank you, sir. Have a seat, please.
Your Honor,
Gracias, señor. Tome asiento, por favor.
we will be accepting his name at the, from the paper.
Yeah, Jose Freddy Ramos,
Yes, ma'am.
yes.
Thank you.
Do you want
Rivas at the end, like he stated?
Yes, ma'am. Twenty-three CT 430, Ismael Hernandez Ibarra. Thank you.
Sí, ¿qué tal? Buenas tardes. Mi nombre es Ismael Hernández Ibarra.
Good afternoon. My name is Ismael Hernández Ibarra.
And what is your date of birth, please?
¿Su fecha de nacimiento cuál es?
Es 17 del 06 del 95.
06-17-95.
Thank you. Sir, you've been picked up as a result of operating a motor vehicle without a valid driver's license.
Bien, señor, a usted le detuvieron por estar conduciendo un vehículo motor sin ser titular de una licencia válida.
The court has I'm sorry, what was that?
That's right.
Okay. The court has reviewed the charging affidavit. I do find there's sufficient probable cause.
Se ha estudiado el documento acusatorio y se determina que existe suficiente indicios de criminalidad.
You do not qualify for pretrial release due to immigration status.
Sepa usted que debido a su estatus migratorio, usted no reúne suficientes requisitos para hacer el programa de libertad provisional.
Bond to be set in this matter in the amount of $500.
En este asunto dado, se fijará la fianza en $500.
You are not to drive without a valid Florida driver's license.
Y usted estará prohibido conducir sin tener una licencia válida de la Florida.
Thank you, sir.
Gracias, señor.
Es una pregunta.
I have a question. Dígame.
¿Es grave mi caso?
Perdón.
¿Es grave mi caso?
The degree regarding this case?
I don't understand your question.
No entiendo la pregunta.
Si es grave mi caso.
Grave, dice usted?
Grave.
Okay, I'm sorry, Your Honor. The interpreter couldn't catch his words very clearly through the system. Is my case very serious?
Well, it is a criminal case, sir.
Señor, esto es una acusación penal.
Sí, está muy bien.
Okay, very well.
Thank you, sir. Next case, 23 CT 439. Yerli Elizer Lopez Roblero, also known as John Doe 3239. Thank you. This was a reset from this weekend pending verification of the identification.
Yes, he had a passport.
Este caso fue aplazado del fin de semana esperando verificación de la identidad de él, si su señoría pasaporte.
Good afternoon, sir. State your name and date of birth, please.
Buenas tardes, señor. Por favor, indique su nombre y fecha de nacimiento.
Mi nombre es Keide Liceo López Roblero.
Mi fecha de nacimiento es el 05/01/94.
My name is Hiler Elicer Lopez Oblero, and my date of birth is 05/01/94.
Sir, you've been picked up as a result of operating a motor vehicle without a valid driver's license.
Señora, a usted le detuvieron por una acusación de conducir un vehículo motor sin ser titular de una licencia válida.
You do not qualify for pretrial release due to immigration status.
Sepa que usted no reúne los suficientes requisitos para el programa de libertad provisional debido a su estatus migratorio.
The court has reviewed the charging affidavit. I do find there's sufficient probable cause.
Se ha estudiado el documento acusatorio en la causa y se determina que existe suficiente indicios de criminalidad.
Bond to be set in the amount of $500.
Se fijará fianza en $500.
And you're not to drive without a valid Florida driver's license.
Y sepa usted que estará prohibido conducir al menos que tenga una licencia válida de la Florida.
Thank you, sir.
Gracias, señor.
Gracias.
Thank you.
Mr. Rohr, can you make an announcement to make sure we haven't missed anybody?
Yes, Your Honor. Si hay alguien más que requiere los servicios de un intérprete en español, le pido que por favor levante la mano.
Ms. Anderson, is anyone raising their hand?
No, Your Honor.
All right. Thank you, Mr. Rohr. Have a good day.
You too. Thank you.
Next case, Ellis Michael Zodos.
President approaching, Your Honor.
Thank you. Good afternoon, sir. State your name and date of birth, please.
Ellis Michael's oldest, September 22nd, 1969.
Thank you. Sir, you've been picked up as a result of a warrant out of Orange County in case number 48, 2021 CT 20420. It's a violation of probation on a DUI matter. There is no bond set on that. They'll be notified that you're here. Thank you.
Thank you.
22 CT 4408, Dylan Olaf Sunday.
Your Honor, he's detoxing. Can we reset for tomorrow?
Do you want me to reset, or you want me to just go ahead and announce it so that when he's finished with detox, he can bond out if he wants to? It's a warrant.
Okay, we'll wait for his appearance, Your Honor, move forward with the bond.
All right, it was a failure to appear for arraignment in that matter. The judge set his bond at $100. 23 CF 641, 22 CT 4486, Joseph Bruner.
Joseph Wayne Bruner, 10/24/1973.
Thank you. So you've been picked up as a result of an arrest warrant that was issued in early January. The charges are possession of controlled substance and possession of drug paraphernalia. Probable cause was found when the warrant was issued. I've reviewed it and I do concur with the finding. You do not qualify for pretrial release due to other legal constraints. Bond on count 1 will be set in the amount of $1,100. Count 2, the amount of $100. You're not to have any alcohol or drugs. Thank you.
Thank you, ma'am.
Your Honor, you have the failure to appear.
Oh, did I miss one? Oh, I'm sorry, sir. Can you come back?
You mentioned them in the beginning, but you.
I sure did. And I'm the one that issued the second warrant. That's my bad. I did call out case 22 CT 4486. That is a warrant for failing to appear for arraignment in that matter. The bond on that one is $1,999.
Your Honor, can I say something?
You can, but it's probably best that you talk to the attorney first before you say something that could potentially have an adverse effect on you.
I was late in the courtroom, and I was there at 9 o'clock, and they wouldn't let me in the door, but I was late that morning. It was on the 26th.
So, Mr. Bruner, I'm the judge that was presiding that day.
Ma'am.
Mm-hmm.
Yeah, I was there at 9 o'clock. I was supposed to be there at 8:30. I was there at 9. I was standing outside the doorway there, and I was trying to wave the officer, and nobody would respond to me.
Well,
But I was
Mr.
wondering-
Bruner, I'm not going to talk about it any further with you because what I will tell you is the doors were not locked. So I've issued the warrant. It's $1,999.
Thank you, ma'am.
Thank you. Joseph Bruner, 23 CT 429.
Joseph Bruno, 05/28/1971.
Thank you. Sir, you've been picked up as a result of driving while license suspended with knowledge. Court has reviewed the charging affidavit. State, I don't see anything in the affidavit that prompted the stop. Unless I just missed it. I see there's talk about a stop that was conducted by Sergeant Lawson, but I don't see anything that tells me what prompted the stop to begin with.
Your Honor, that I would concur that detail is not in the PC affidavit. However, that's not an element for the offense. That would be a later constitutional issue as to whether the elements are driving and was it suspended, and those elements are present within the affidavit.
Well, I don't disagree with you. You have to have the probable cause for the stop to begin with. You have 24 hours to submit a supplemental affidavit from Sergeant Lawson as to why he pulled this man over.
Thank you, Your Honor.
Sir, your case is going to be reset for 24 hours to see if they provide me the probable cause for the stop.
Thank you.
Thank you. Can you make sure I get that face sheet tomorrow? Ryan Nguyen?
He's present for question, Your Honor. Defense does have a request regarding conditions of bond.
We'll get there in just a moment. Ma'am, put your purse on the bench, please. Good morning, sir. State your name and date of birth, please.
Good afternoon, Judge. Brian Kwok Nguyen, July 6, 71.
Thank you. And ma'am, state your name, please.
Don Drew.
Thank you. Ma'am, can you raise your right hand to be sworn, please? Raise your right hand to be sworn. The other one. You solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. You can lower your hand. We are here today because you have been picked up on the charge of battery, touch, or strike. Court has reviewed the charging affidavit. I do find there is sufficient probable cause. Ma'am, as the victim, you have the opportunity to address the court with regard to release restrictions. It is not a time to talk about what did or did not happen. I'm only focusing on the restrictions related to his release and his bond today. With that in mind, what would you like me to know?
I don't want to red charge him.
All right, well, that's outside of my control. It's actually up to the state attorney's office to determine whether they press charges or not. When we're finished here, if you want to go to their office on the 3rd floor, you are welcome to talk to a victim advocate there and let them know what your wishes are. But ultimately, it's up to the state attorney's office to determine whether they move forward with this case or not.
Okay.
I am imposing some conditions as requirements of his bond that is going to keep him from coming home. Okay? As I said, I found probable cause in my review of the affidavit. You qualify for pretrial release with a bond. That bond will be set in the amount of $1,000. You're not to have any contact with Doan. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand, sir?
Yes, I do.
You're also not to have any hostile contact with the 2 children that were present during the incident. Do you understand?
Yes, I do.
You're not to return to 3624 Weatherfield Drive. You can go back one time with the assistance of law enforcement to obtain, it's another judge, to obtain your personal items only. You're not to have any alcohol, drugs, weapons, firearms, or ammunition. Do you understand?
Yes, I do.
All right, counsel, did I cover everything for you?
You did, Your Honor. I was just going to request no hostile contact for the alleged victim as well. The note that I received this morning from PTR indicated that the victim wished to have contact. The defendant does share children and a residence with the alleged victim. So at this time, that was going to be defense's request.
Unfortunately, I'm not going to be able to grant that request. It'll remain no contact for now.
Thank you, Your Honor.
Thank you. Thank you, ma'am. You're welcome to go down to the third floor and speak with the state attorney's office,
Can I
okay?
have a question?
Yes, ma'am?
How long he cannot in contact?
Until further order of the court. Thank you. 23MM222, Carmen Rivera.
She's present and approaching, Your Honor, and defense has a probable cause challenge for this case.
Good afternoon, ma'am. State your name and date of birth, please.
Carmen Rivera, 62491.
Thank you. Sir, can you state your name, please?
Jonathan Hodge.
Mr. Hodge, would you raise your right hand to be sworn? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You can lower your hand. We are here today due to a battery, simple touch, or strike in a domestic relationship. The court has reviewed the charging affidavit. Counsel, you said you had a probable cause challenge?
Yes, Your Honor. Ms. Rivera was charged with battery under Florida Statute 784.03. The statute requires that the defendant actually and intentionally touch or struck the victim against his or her will. And defense would argue that in the affidavit, the victim states that nothing had occurred, that the suspect was lying due to wanting to be arrested, and he continued to deny any physical altercation occurring. So defense would just argue that if there was any touching, it was not against the will of the victim.
Counsel, can I ask you a question? Under the charging affidavit, it says the suspect advised the victim accused her of cheating, so she became frustrated and punched the victim multiple times in the face. Do you think he asked her to punch him multiple times in the face?
I do not, Your Honor. However, the victim also said that the suspect was lying and just wanted to be arrested. So I'm just considering the facts in this charging affidavit. It seems to maybe not give rise to probable cause.
Well, as you are aware, probable cause is a very low threshold. I am finding probable cause in this situation. Mr. Hodge, as the victim in this matter, you have the opportunity to address the court with regard to release restrictions. It is not a time to talk about what did or did not happen. It is a time for you to indicate to me what it is you would like to see. Understanding, I'm not obligated to honor your wishes. I'm going to make my ruling based upon my review and all the information that I have before me. So with that in mind, what would you like me to know?
One, she had a baby last week. Two, I would like to have contact with her because, she could, yeah. That's all I can really say. She had a baby last week. She's under a lot of emotions. I told the cops that did not happen. I don't know why she said that, and I can't change her words, but I didn't say she punched me in the face because that's not what I said at all. But that's all I can really wish you could have contact with her and that she did not touch me. And the call that was made was not for being touched, it was just for a verbal disagreement.
Ma'am, you qualify for pretrial release with a bond. The bond is going to be set in the amount of $1,000. You are going to have to maintain separate residences. I cannot allow you to live together. I will allow you to have contact in light of the fact that you have a newborn together, but that contact is to be no hostile contact. Ma'am, if you find that you are getting aggravated in any way, shape, or form, whether it's about a baby or it's about cheating or whatever else comes to mind, you need to remove yourself from the situation, because if you do not, and the police are called, whether it's by Mr. Hodge or someone who overhears you, you are the one coming back to jail. Do you understand that?
Yes, ma'am.
And if you come back to jail, your bond in this matter will be revoked, and you'll be there until you see the trial judge on a different motion. Do you understand?
Yes, ma'am.
So there'd be no hostile contact. Anything further, Mr. Hodge?
I said thank you.
All right. Thank you, sir. Good luck to you.
Thank you.
Dennis Samarine, thank you. I see. He's taking pity on me and coming up anyway. Good afternoon, sir. State your name, please.
Dennis San Martino, 9/14/1988.
Thank you. Sir, you've been picked up as a result of battery, touch, or strike. The court has reviewed the charging affidavit. I do find that there's sufficient probable cause. You qualify for pretrial release with a bond. That bond will be set in the amount of $1,000. You are not to return to 4011 Greenleaf Drive. You can go back one time with the assistance of law enforcement to obtain your personal items only. You are not to have any contact with Ivy Moss. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
Yes, ma'am.
You're also not to possess or consume any alcohol or drugs.
Yes, ma'am.
Thank you.
I do have a question.
Yes, sir.
Is pretrial release as well as bond? Or
Yes,
are those
sir.
two separate things?
No, it's pretrial release with a bond, and so basically they will monitor the conditions of your release, okay? Thank you, sir.
Thank you.
Samuel Sereno Osorio?
President approaching, Your Honor.
Thank you.
Good
Good afternoon. State your name and date of birth, please.
Samuel Ruben Serrano Osorio, 11/16/1986.
Thank you. Sir, you've been picked up as a result of failing to register a vehicle. The court has reviewed the charging affidavit. I do find that there is sufficient probable cause. You qualify for direct pretrial release. Given the charge, the court will grant direct pretrial release with the condition of no driving.
Yes, ma'am.
Do you understand why I'm saying no driving?
Yes, ma'am.
All right, it's because your license is suspended. So make sure you're not driving while it's suspended. No, don't offer anything. Just going off of what the affidavit says.
Yes, ma'am.
If your license is suspended, do not drive. If it is a valid license, you are welcome to drive.
Yes, ma'am.
Thank you, sir. Megan Starcher?
She's President approaching, Your Honor.
Thank you.
Megan Starcher, 9/21/96.
Thank you. Sir, state your name, please.
Pedro Solar.
Thank you. Mr. Solar, would you raise your right hand to be sworn, please? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. We are here today for a battery, touch, or strike. Court has reviewed the charging affidavit. I do find there is sufficient probable cause. Mr. Solar, as the victim in this matter, you have the opportunity to address the court with regard to release restriction. It is
No
not.
restrictions, please.
Hold on one second. It is not a time to talk about what did or did not happen. It's only with regard to release restrictions. Understanding, of course, that I'm going to take everything I've reviewed and heard into consideration when I make my ruling. So I may or may not honor that which you are requesting. With that in mind, what would you like me to know?
No restrictions, Your Honor.
All right, well, Mr. Solar, I'm not going to be able to do that. Ma'am, you qualify for pretrial release with the bond. The bond will be in the amount of $1,000. You're not to have any contact with Pedro Antonio Solar. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
Yes, Your Honor.
You are to maintain separate residences, and you are not to possess or consume any alcohol or drugs. Thank you. Thank you, sir. Ray Stiles?
He's President approaching, Your Honor, and defense has a probable cause challenge as to the charge of driving while license suspended. Knowledge.
Good afternoon, sir. State your name and date of birth, please.
Ray Styles, 2/11/93.
Thank you. Sir, you've been picked up as a result of possession of cocaine, possession or use of drug paraphernalia. We'll deal with that one first. As to count one, let me back up. You don't qualify for pretrial release because you're already out on bond on 2 other cases. With regard to count one, bond to be set in the amount of $2,500. Count 2, the amount of $1,000. You're not to return to 1300 East Donegan, which is the 7-Eleven. And you're not to possess or consume any alcohol or drugs.
Yes, ma'am.
The next matter is driving while license suspended or revocation. Counsel, you said you have a probable cause argument?
Yes, Your Honor. Mr. Stiles was charged with driving while license suspended under Florida Statute Section 322.34, subsection 2. The statute requires that the defendant drove upon a highway in this state and that at the time he knew that his license was suspended. The charging affidavit only mentions that he was parked at 1300 East Donegan Avenue in Kissimmee, Florida. It does not mention whether that was a roadway, whether that was a residence. So as to the first element, I would argue that the facts don't give rise to an indication that he was on a highway in this state. And then regarding knowledge, the affidavit merely says that law enforcement did an inquiry which resulted in Mr. Stiles having a suspended license for a previous attempt to flee. But there's no mention of a citation, a notice by mail, or a judgment indicating that Mr. Stiles had knowledge, and Mr. Stiles never verbally told law enforcement that he had knowledge of his license being suspended. So at this time, defense would argue that the facts are insufficient for probable cause as to that charge, Your Honor.
So I'm going to deal with the knowledge one first. Counsel, he's actually out on bond for driving while license suspended. That is definitely imputable knowledge to him since he's out on bond for it, which means he's already seen a judge on that issue. With regard to the not driving on a highway, if you look at the affidavit, it says that he was backed into a parking spot, hiding the license plate, when the officer made his way toward the U-Haul to make contact with the driver, who was sitting in the driver's side seat with the door wide open, foot on the brake, and engine running. No, sir. No, sir. We're not going to talk about the facts of the case today. This is a matter of finding probable cause, but thank you. So, counsel, I do find that there is probable cause, both with knowledge as well as with the fact that he was driving. Bond in that matter will be $500, and he is not to drive unless he has a valid Florida driver's license. With regard to the two cases that he is out on bail, 22 CF 12718, which is a fleeing and eluding police, driving while license suspended, and then 22 CT 7365, driving while license suspended, bond will be revoked in both of those cases and set at $0. And then we also have possession of credit cards or debit cards that were stolen. Court has reviewed the charging affidavit. I do find that there is sufficient probable cause. Bond to be set in the amount of $1,500. Thank you, sir. Here, I got you. I always have some in my room. Mm-hmm. Gregory Tenon.
Gregory R. Tenon, September 29, 1951.
Thank you. Sir, you've been picked up on a couple of charges. The first is driving while license suspended or equivalent status. Second, or subsequent offense, a no motor vehicle registration and attaching registration or license plate not assigned to the vehicle. The court has reviewed the charging affidavit. I do find that there is sufficient probable cause as to each of the charges. It appears that you qualify for direct pretrial release. Given the nature of the charges, the court will grant the direct pretrial release. Thank you. Counsel, did we miss anyone over there?
No, Your Honor.
All right, thank you. Have a good day.